Lordship kindly peruse this last sentence. So 4 accused persons are there. 3 was allowed by your Lordship. And BLFPL is disposed of. So far as 3 is concerned, move after ensuing summer vacation. That is the hurdle to.
What do you want?
Sita modify our other.
Move application. Without application, how can I do it?
Your Lordship, keep it put up tomorrow. I'll just now filing the.
Let the application be there. I'll do it.
File
Modification will come to me only. Don't worry. Do it.
Division bench.
No. Partly I'll sit for single also. Don't worry. It will come. Don't worry.
In Friday.
Friday. Memo
File it. What exactly what correction you want there?
That so far as since bail application is disposed of, so far as the 3 is concerned, liberty granted, move before the court.
You want to? Okay. I share that after winter vacation it will be. You will reach there. Okay. Yes.
ସେଇଟା ପାଇଁ ତଳ କୋର୍ଟରେ ବି ଆଜ୍ଞା ସେ ମନା କରୁଛନ୍ତି accept.
I know, I understand it. It will not be listed. At least you try there.
Yes. 379 offense.
That's
yes.
Item number 7. Mr. Palit is out of station. May kindly be taken up next week.
7.
Yes, ma'am.
Okay. On the request of who is out of station?
Mr. Palit, Senior Counsel, Mr. Palit.
On the request on behalf of zones. Yes.
Yes, next week need it.
Yes.
Any mention on the list?
Yes. Start.
Item 1.
Yes, madam.
I have filed this application for questioning of the entire proceeding on the ground that there are several disputes between the parties. The fact of the case is that we are claiming that there are 2 temples. One is at village Monthidi and another temple is at village Horodongo in the district of Ganjam.
Horodongo
and Monthidi.
I will not hear. I was the lawyer there for this district. There in Supreme Court, I handled this. I was appearing for endowment commissioner.
Oh, for that endowment.
Endowment commissioner, this dispute went there.
Remand.
Remand. I was the lawyer. Leaks matters before some other bench. I'm not the party.
Interim order type आपण कंटिन्यू करेबे
सेटा तो रहला.
Yeah, I will not. It is there.
Order टे पास कर देले सेति मु करछि. सेटा खाली लेखा है जे adjournment petition दबो.
Whatever, I can't.
That will continue.
I simply list it next week, before appropriate bench. Next week, since next week. Because I know the collector or sub-collector was appointed as a administrator there, and they went challenging that order.
Yeah. Sub-collector.
Back to that.
I was the council conductor.
Challenge kolo Supreme Court. Court college there are 2 institutions. Kintu remand kar dele I points to.
That's I know.
Item 2.
May please.
Second matter. Director of the personal appearance of the IIC appellee. He is coming.
Okay, I'll pass it over. Let him come. Only to know whether he has filed the charge sheet. You want to file or what?
Today he is going to file charge sheet.
Because I issued notice.
Yes.
He could have done it earlier also.
Yes, exactly.
Yes.
Item 3.
My lords, on last occasion, your lordship had asked me to get instructions if my client is willing to deposit some amount. My lords, I have instructions. My lords,
How much?
That's 4 weeks time and given, my lords, to gather the amount. But your lordship had asked me to ask if the client is willing to deposit 20%
of the amount.
That's what I will.
Then I'll record it.
Also,
Otherwise, what happens is your client is
settlement
he's changing counsels and he's doing all
filing petitions after petition.
I know.
Also, if
My lord,
the
on the
20% can be reduced if
Then I will not say anything. I'll not say anything. Why should you prejudice you? I'll not say anything.
My lord, on the last
Counsel
occasion,
for the petitioner seeks an adjournment to on instruction and counsel for the petitioner submits that the petitioner would rather prefer to deposit certain amount, prefer to deposit the check amount or check amount and settle the dispute instead of further precipitating the issue. Hence he seeks for this time, release the matter also. Yes.
And let this matter be come along with contempt number 5 of 25. This
Release
was
the matter along with contempt.
CONTR number कारण पूर्व ऑर्डर है CONTC हे जाइथिला CONTR number 9
Let release the matter of course. Meanwhile, arrange the funds and give something and finish it up. Yes. If you have financial difficulty, installment can be fixed, something can be done. But this is no way. Try and do. Okay. Yes. Four deleted. Yes.
Item 5.
Five.
May I please, your lords? It's a case under section 20B of the NDPS Act. My complicity is that, allegation that the police getting information that some unknown persons have stored some contraband gun in
What is the
the
stage of investigation?
investigation is still going on.
So then,
So, my lord, the allegation,
let the investigation be completed.
my lord,
And
no person, no, just what I submit. Allegation that getting such
NDPS
info-
case at the
that is-
stage
what
of investigation you want.
what I submit, my lord,
I
this
give
is
you
similar-
liberty to renew your prayer after the charge.
my lord, may I, my lord,
20 pointers.
No.
I'm not going, why to waste time?
no, that similar types of orders, I mean, surrender. This order has been passed in.
This is quashing petition.
it was 482 ଅଛି.
Quashing petition you are asking,
ସରେଣ୍ଡର ଖାଲି ଅର୍ଡର କରିଦେଇଛନ୍ତି ସେମିତି ବି ନହେଲେ ଚାଲି ଯାଉ ସେରକମ ସରେଣ୍ଡର କରିବା ପାଇଁ କୋ ଏକ୍ୟୁଜ ଅର୍ଡର ଟୁ ଅର୍ଡର ସରେଣ୍ଡର ପାଇଁ କହିଛନ୍ତି ସରେଣ୍ଡର ସେମିତି let them take a chance till that investigation is going on and complicity that 6% they fled away from the spot. That is the only
20 pointers.
but Buka. That is
petitioner is seeking, petitioner is one of the accused in FIR number so. He seeks quashing up to the entire criminal prosecution initiative. And what you say, submit that to the investigation in the nation state and charge has not yet been filed. Mr.
Similar-
Jaffrullah, Mr. Jaffrullah,
similar
counsel-
another co-accuser.
counsel for the petitioner submits that although he has a very good case on merit for quashing up for reaching for quashing for criminal proceeding, however, at this stage he would not press for the same, rather reserve the right to vegetate the issue at the appropriate stage. At the same time, he further submits that his client preferred to surrender before the court and resort to the remedy available to him under law. Mr. Jaffrullah further taking me to the FIR and seizure list, etc. submits that the bar under section 37 NDPS Act may not be attracted in the present case. Be that as it may, the present petition is disposed of with liberty as the let the petitioner surrender before the court below and resort to the remedy available to him under law. All the issues as raised in the present petitions left open to be addressed.
Parity of the parity.
No.
Yes,
next. I have
if that is
given-
not raised that point.
Even
question of parity. If that
Mr. Jaffrullah further submits that he is entitled to the parity with other accused persons, those who have got the similar relief. Which open to take. Yes.
Item 6.
Lots of items. You can pass it over.
Pass over. Yes.
Item 8.
7.
Seven.
Somebody mentioned it.
ନା, ନା,
8.
ଏଇଠି ହଉଛି 500 ବର୍ଷ ହେଲା ଏଇଟା ହଉଛି ଏନବିଡବ୍ଲ୍ୟୁ ମ୍ୟାଟର ମାନେ
Huh?
Item 8 is individual matter.
So I'll cancel it and we will work.
Petition was Allen Bell on 9/6/2023. Page.
Petitioner submits that 12. Petition is accused shown from case. And you were on bail earlier.
Earlier
Bail
bail
order.
bail minor 9/6/2023. Page number 11.
Petitioner was on bail on
9/6/2023. Bail
granted by
granted by
trial court.
trial court matter.
Trial court based on nothing out of petition. However, due to his default in appearance in the court by order dated 8/4/2025, NBW has been issued against him. His was went up for the same. And the takes the formal order to the 500 rupees. Paper 9
9/6/2023.
1,000.
Order is there.
1,000. Yes. Yes.
Item 9.
One. I could bar it. 1,000. And
Bill
yes.
against conviction 304B 498A and 4 DPI.
Chonu ka भी order दीजिए. So called it 389. Yes.
304 part 1, 10 years.
11.
11 years.
Okay. Admit. Delay nahi.
Delay.
Admit. Call for TCR and appoint someone as a MRK security. Being
10-year
being-
punishment. Okay.
This is the jail criminal appeal against this is the jail criminal appeal against the judgment and order dated so convicting the appellant under section so and sentence so. Thereafter you write admit and so is engaged with the counsel. 12
44 days of delay.
delay condone
376 and POXO is there. 20 year of punishment.
jail criminal appeal so delay condone POXO since POXO is there issue notice to the informed
And TCR we call it.
and TCR call that is standard order.
Yes.
Yes. 13
13.
13 nobody is there 13 it's a it's a 376 J
76 and 450.
POXO is also there. Open करोगे they will I will just tell the names. Okay.
14 POXO is there, Your Worship.
POXO
5 year of punishment.
issue notice. No delay. 20. Modification. What modification? Huh?
Flag V, we call it.
Flag V. Ah, yeah, application for recovery of the song. Recall. Nobody is there. Pass over. So, dismiss.
21.
21. 21. What modification?
Flag.
Flag here is on. Family should shall be of position. President should present in custody for the electoral. Housing more than 2 years in the past. Citizen not moved to the station. What is this?
21 is no?
It's supposed to be different outside of the-
जी.
4 lakhs he has made the statement. No, issue notice to the informant on the application. To the informant in this app. Yes. The application, huh? Yes.
22.
It's an application, issue notice to the, yes. 22.
22.
Yes. Again, modification.
Modification flag K.
Okay. What? They take the order thereafter. And reading the petition. Pass over. Cool. Dismiss. Yes.
23.
The extension of that is surrender lordships. Would not surrender is because
24, I have given the time to
yes, yes,
surrender.
my lord, because he is the out of state lordships.
7/3/2024. 1 year, more than 1 year.
But he is out of station, he could not communication gap, could not
Then
surrender.
this,
And the
shall I send the magistrate to your house?
No, my lord, the
Did
cost
they-
was deposited, my lord, any condition, my
What
lord.
was the cost? 500. You
Yeah.
now pay 1500, the bar, 1 year, 1500, last extension, up till you
That's
tell me. Up till
within 2 weeks, my lord,
2 weeks means it will be over by 27.
my lord.
By 27, subject to petitioner paying, this is an application for the extension of time to surrender pursuant to the order dated 15/2/2024. For the reasons stated in the application, the same is allowed, subject to the petitioner making a payment of paying a cost of rupees 1500 to which bar? High Court Bar Association. High Court Bar Association, Welfare Fund of High Court Bar Association. Let the petitioner surrender on or before 27th of January, so and so, and resort to the remedy available to him under law. It is made clear that no further extension on any ground shall be granted. Yes.
Obliged.
24.
Sibo? Yes. Issue notice to the opposite party. Whether notice is served, just check it out.
Notice that the notice issued to sole OP returned answered with a postal endorsement as address left without instruction, hence returned to the sender.
Okay.
Maybe fresh,
Press notice.
fresh address, your lordship.
Fresh address.
Fresh
Correct
Correct address may be furnished.
Order dated 23/3/2025. Notice was issued to the opposite party, but the postal remark indicates that the address
Address left
given in the
without
petition is
instruction.
insufficient.
No, address left without instruction.
Without
So maybe
address is left without instruction. Inverted comma. Hence, the petitioner is directed to furnish the fresh address of the opposite party number 2.
sole
The
OP.
opposite party. This is 138 metro what? Okay, this is metro. This is a fire what? Complaint case. Complaint case. Okay, lease the matter. Yes, next.
25.
125, 127 of mint.
Yes.
25 million. May I please, your lordship, here I have challenged my petition to discharge was rejected by the learned court below.
Okay.
My lord, can you have a glance to the annexure 1, the FIR?
Hmm.
And the written FIR is at page
Yes.
12 of the brief.
Hmm.
So, may I place it, my lord? Page 12.
Hmm.
The above named person received 40 lakhs from the undersigned for sale of land of 60 decimal at Dairy Palace, Sambalpur. It was not materialized. Hence, he made an agreement. Well, at the word, he made an agreement to return the amount which was settled to be 35 lakhs as final payment to Dr. Such and Such on.
I'm issuing notice, bring him.
My lord, already notice was issued, my lord.
No, notice was not never issued.
No, sorry, notice was not.
Never issued.
Neither he is receiving phone call.
That's
nor
right.
paying money.
So therefore, I'm issuing notice, bring him. Have you implemented him as a opposite party number 2? You've not even implemented, taken the money, not picking up the phone, not implementing him also.
It is a GR case, my lord. It is
Whatever,
a GR
but
case.
see, ultimately it is a money matter.
Money matter, my lord, and it is an agreement and it is civil in nature. He has received part of the money, my lord.
You have to pay, as simple as that.
He has already filed to NIA case that is pending.
So bring him, I'll try to
That is
settle
the
it.
fact and subsequently NIA.
No, sorry. See. The NIA
Now-
case is of
Now charge
2017.
has been framed against you.
Yes, my lord.
Then file a revision then. I'll give.
Well, revision I have already filed before this sessions court.
Acha,
That,
rejected.
that was rejected. Against that I have come here.
Two courts have gone against you, then you have a difficult case. Will you settle the dispute or not? Simply by implementing him. I'll issue.
My lord, this NIA case is pending against me.
Maybe.
Two number of cases.
All the cases will be over. All two NIK case and this also. Because you are adamant not to pay. You have taken the money and
No, I have
stopping him
already
in the technicalities.
I have already paid part of the money he has received.
Then there is a chance
No.
of settlement. There is a chance of settlement.
Hold it, 6 lakhs thereafter he has also
See,
received.
Fact remains that by promising to give land, you have taken the money. Now you are fighting out the case on technicalities
No,
to avoid the money to be paid.
I have issued check were dishonored.
Then
He has filed
more reason that why have you issued check?
because to
Admitted liability you have issued check.
yes, my lord.
Then you are see the conduct also.
No, yes, my lord. That's why yesterday.
Therefore, he will be fighting for
My lord,
years
I'm
together. He
protect-
will not pay. That's the idea.
No, he has to go for
You
civil
keep
suit, my
on
lord.
fighting on technical grounds
My lord,
and don't pay the money.
That's
That's
what
the
the
whole
Honorable
thing.
Apex Court also stated that.
Apex Court what stated I don't know, but I'm stating you that implead. I'll issue notice. I'll try to.
Yes, sir, just now I will implement, my lord.
Let us consider the petitioner submits that he would seek leave to implead the
Informant.
informant in the present case. Once he impledes the informant as opposite party number 2, issue notice to opposite party number 2, written within a week. the notice be also served through the IO of the case. IO of the case. Let them come, all 138, and this matter, everything will.
I have filed IA for interim. No, my lord, I will file a.
No question. See your conduct.
Well, I'll
You
file
taken
adjourn-
money, given check,
My-
which
my
are these
lord,
are
charge-
now
charge-
your technical ground. You are saying within 2 weeks nothing is going to happen.
No, my lord, charge has already been framed.
It's all right.
I have to trial.
Court
will
is
be-
not powerless to. I'll record it. Okay, right. And counsel for the petitioner further submits that he is ready and willing to settle the entire.
No, my lord, that part.
Otherwise, I'll not give.
That part I cannot, because without instruction I cannot
It's not-
surrender, my lord.
it's not.
But charge is framed and that now it is.
But I will not interfere then.
No,
If
my-
you want, I will dispose of. I'll pass it.
What I submit, my lord,
Hmm.
I will file adjournment petition before the court.
No, no, no
till next
question.
date.
Your conduct is not there's good conduct so that I can give indulgence to you. You implead him, bring him, then I'll try and within 1 week nothing is going to happen.
That's the whole tool, my lord,
And
that-
file the requisites within 2 days. Within 2 days, through IO also service will be available.
Yes, sir, I will serve an extra copy on
Yes,
the government council.
extra copy to the
Go-
government
go-
council.
this. But my lord,
Bring him, we'll
my lord,
settle everything.
till then, my lord, trial, my lord, because if once trial start, my lord,
No question. Do you know? From 90s, cases are pending in this court. 1990.
yes, my lord,
Stay is taken and thereafter adjournment.
I don't dispute that, my lord.
Then
But my lord,
why? Because of this approach.
no,
You come.
let them assure
I
that.
will dispose of this matter as well as both the 138 matter. You bring him.
Yeah, I will bring him.
Will you bring him tomorrow? I'll take it up tomorrow.
I cannot assure that, my lord, tomorrow,
Ah.
because
So
he is the
therefore-
opposite party. Why should he listen to me?
No, but through IO, I'm serving.
Uh,
Through IO, I'm
through,
serving. So
but-
that he'll come, definitely. He'll come.
And as far as my contention, my lord, I am totally supported by a decision of 2025 of Honorable Apex Court.
There are other decisions also.
But all the decisions has been taken care of by the Honorable Apex Court.
Therefore, I issue notice to him also. I will hear it. I'll hear it. No. Yes.
But my lord, at least till then, my lord, till then, my lord, once,
Next slide. Please.
26.
my lord, if the once the trial will start, my lord, that will take
Nothing will happen. Nothing will happen.
Definitely,
You are not,
once-
you are not going to be hanged. With
No, my lord, once the witnesses will examine, my lord, I will be pleased. That's why I am praying. I will file an adjournment petition till then, my lord. Let the court below.
Please hold on. I'll put it 1 week before. Next week, I can give it. I'll give you a date also if you want. Let it be on 20th. 20th. Serve immediately. Today is 21st. 21st. Serve immediately. We'll sort it out.
Yes, sir. So I will correct the perspective here.
So everything is digitalized. You should have implemented.
Scan of
So I will serve a extra.
Do it today itself. So that 21st I can take it up and finish up.
Well, then I have to file a IA again to implement him as a party.
I have already given you permission on oral press.
Oral press.
I have already allowed.
No.
I have already allowed. Yes. Yes. Next.
Consolidated.
Yes. 21st, huh?
Yes, ma'am.
21st, yes.
26.
May it please your lordship, I am appearing on behalf of Mr. Alok Mahapatra, sir. Your Honor, last occasion, Your Honor ordered the both parties to appear before this court.
Have they come?
Yes, sir, they are coming, sir. A short fast for me.
Yes.
Obelisk.
27th.
Matter, my lord, I have to ascertain the stage of the trial. Here I have challenged a rejection, my lord, petition, wherein my prayer to call the victim child for DNA examination. This is a my lord case under Section 6 of POCSO Act. Now, my lord,
The petition was convicted for commission of offense on section 376 of the Indian Penal Code.
Yes.
At the outset, I would like to bring my lord's kind attention that during course of trial, he was on bail.
Yes.
And after the conviction, he approached this honorable court by filing the bail application, and during his custody, he was ill and ultimately he was referred to different hospitals, and accordingly, this court was pleased to grant him interim bail. Thereafter, I surrender and file the surrender certificate. While
Which order? The interim bail order?
Lordship,
17/11/2025. First and second is Miller's 4/12/25.
Twice he was granted interim bail.
Twice.
17/11,
17/11/25.
17/11/25 and
4/12/25.
4/12/25. What had happened to her?
An applications for extension of that.
no, extension, let me say that koi.
Yes.
What happened? A petition was filed for extension in the mean period that was become infructuous in view of the lapse of the time, and he surrendered. While passing the last order, this honorable court was pleased to direct the state council to obtain the health condition of the petitioner.
Yes, sir. You got it. No, I'm not looking. It was discharged.
My lord.
Discharged, yes.
Another aspect I will bring my lord's kind attention, the latest medical document which show that it needs operation.
After this.
Needs medical operation on 20th.
This is January 20.
20th.
Or this report is somewhere
Report is that
13 January. This 13 January. Thereafter, in 26 January, the doctor has advised him for admitting. Subject, let the trial court verify it and leave him. That's what I'm saying. Right. This is the accused. He was convicted in sentence. During the trial, the petitioner was on bail. However, after the judgment was pronounced, he was taken into custody. The matter is pending since 2025. The appeal is pending since 2025. Meanwhile, on 17/11/2025, the appellant was enlarged on interim bail for a period of 2 weeks. 2 weeks. And subsequently, it was extended for separate order that you surrender after 17/11, you surrender?
Yes, only.
Or you sought extension?
extension.
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 Subsequently, by the order dated 4/12/2025, the interim bail was extended for another period of extended for further period of 2 weeks. Further period of 2 weeks. By the order dated 4/12/2025, the State Council was also directed to obtain instructions regarding the health condition of the appellant. The State Council has placed on record a report dated 13 January 2026. The report reads as that. It is Mr. Mahapatra, Land Council for the State Council for the EPIC convict appellant submits that pursuant to the order dated 4/12/2025, he has already his client has already surrendered, and he had gone to show his Health. Which doctor is this? Medical, HEV medical call. HEV medical call. Yes, place on record. You have to place on record this one. Yes, place on record the photocopy of the prescription dated 6/12/2025. 2025. The doctor, treating doctor, has advised the appellant to undergo surgery. Undergo surgery. Relying upon the medical certificate, he seeks interim bail for a period of 4 weeks. Regarding it to the aforementioned, I am inclined to the trial court is directed to verify the authenticity of the certificate placed on record by the appellant. Appellant certificate dated prescription medical document dated 16/12/2025 and enlarge the petitioner, enlarge the convicted appellant on interim bail for a period of 4 weeks with the condition as the petition proper. Verify and do it, please. I'll dispose it up. What is this matter? This application is disposed of then.
कुठं नाही bail, man bail petition था वो. On merit मध्ये there is a very good case for to grant bail.
No. I will say that the bail application is disposed of. Which bail application was that? 3310.
IN number 93.
Huh?
93.
Where is that 93? Huh? 93 of 25. This is interim bail, no final, regular bail.
That was the man bail application.
I'll dispose it up to renew the bail plea after sentence.
Yes.
The IN number 93 of 2025 is disposed of with the liberty to renew the plea after the appellant surrenders on the expiry of the interim bail plea.
More, my lord. I got the decision, my lord. State of honorable, my lord. I got the decision today. 32.
I will take it up. Yes. Next item.
34.
Yes, item 2, personal appearance of IIT. Item 2. Yes. Yes. When the FIR was registered? In the year 2022, on 9th October 2022, the FIR was registered. Yes. Yes. Pass over.
41.
So all these matters, interim orders are there. So therefore, everybody is casual. That's the- Yes, which item?
40.
Okay, 40. Yes. 40.
And we pass over.
Pass over?
Okay.
Okay, pass.
40 and 41 both.
40, 41. Both. Okay, pass over. 42.
42, my lord. Counter, the counter has been filed, but copy not served.
You are appearing for?
I am for the petitioner.
Okay.
Opposite party number 2 wife appeared and filed counter.
What are you seeking?
Quashing of a criminal proceeding.
What in the quashing of criminal proceeding? What counter, rejoinder, and all? I don't know.
Rejoinder. Lord,
Why
in view of
is
the, in view of the order of this Hon'Ble Court, the matter has already been amicable settlement between the
Report to the mediator and mediation.
Acha, mediation
Minor.
successful.
Minor.
Mediation successful.
mediator.
Who is appearing for the opposite party?
appear करके counter file के मुझे copy देगी.
Call who is appearing?
Let it come 1 week after.
Why 1 week? Mediation is successful. We'll dispose it up in terms of mediation report. Who is appearing? Who is the counsel? Who is the counsel?
Counter copy not sir.
Chaitanya Naik. Chaitanya Naik.
B.R. Mohanty, advocate for the opposite party, and Chaitanya Naik for the petition.
I'll just pass over. Call them. I'll dispose it up. Dispose it up. Yes. Unless these matters are pending. Yes. Yes. 43. Yes.
My lord, I may be pardoned. The conducting counsel, Mr. Amitabh Tripathi is out of station. On his behalf, I am praying for an adjournment.
What is this matter, by the way?
My rejection of a 311 petition. My
Is there any order? There is no interim order.
I am for the informant, my lord.
Is there any interim order, I'm asking?
Interim order.
It seems there is no interim order. Adjourn for 2 weeks. There is no interim order, let it be adjourned. So it will be infractuous subsequently.
No, he wants to my lord, recall that evidence, my lord, of PW victim, my lord. Once again, I want to, my lord, examine once again.
By the time the trial will be over. Don't worry. If there is no stay, trial must be proceeding, no? Why are you so surprised? There is no stay. He's seeking for recall of some witness. I don't know. The trial might have been over by now.
I'll take instruction, my lord.
List it up on request. List it after 4 weeks. Since there is no interim order, why do you worry?
44.
44, my lord. Watching of proceeding, husband and wife is put, my lord. And as per the direction of the Honorable Court, my lord, on 10/9/2025, joint affidavit filed, and both husband and wife are also present.
Yes.
And joint affidavit,
Give me joint.
joint flag
counsel for the petitioner. On last occasion, it was ordered for appearance of the petitioner with personal appearance. Lordship, due to certain reason, he couldn't appear today.
Okay.
Can he be posted to next week?
The land counsel for the petitioner seeks an adjournment.
Hearing for OP number 2, he is present in the court today. So his personal appearance is given.
My personal appearance was sought for why?
Petitioner as well as OP number 2.
What is this matter? Let me understand first.
The transaction, the work he has taken, and then he has not been, petitioner had not paid the amount for which the OP number 2 had lost an FIR. And now the matter.
What is the amount?
It was 3 crores or more.
3 crores.
My lord. And the matter has been settled. The matter has been settled through mediation. Now, your lordship, your petitioner has filed for quashing of the FIR. So as per the lordship, there is the last order, OP number 2 was to be present.
Then I'll dispose it up.
And let the petitioner know, my OP number 2 is there, so personal.
Why is that? The unnecessary, see, he's there. Call through visual mode, let him appear, I'll dispose it up.
Lordship, on the next week he will appear in.
Why? He is accused.
Yes, Lordship.
He needs an invitation.
No, sir. Sir,
Let him appear in video conferencing mode, 2 o'clock. Tell him to appear.
Okay, sir. Lordship.
Dispose it up unless these matters are pending. There is no reason for pending.
Inform him.
Tell him to appear at 2:30, whatever. 2:30, make it 2:30.
Yes, Lordship.
Through VC, let him appear. You will identify.
Yes,
The
Lordship.
mediation report must be there.
Yes, Lordship.
Mediation report is there. In terms of mediation report, I'll dispose it up.
Yes.
He is also there.
Yes,
Why unnecessarily troubling them to come once again?
Yes, Lordship. I will inform him.
verification of his identity.
Yes.
She is there. She is appearing as a lawyer.
Well picked.
Okay.
But the
Yes, Lordship.
transaction has been completed or not?
Yes,
So
yes.
final-
Money transaction has been completed.
There is
Yes,
nothing
yes,
remaining unnecessary. This is a burden on the system. Okay. Okay.
Lordship,
2:30.
OP number 2 will be.
Let him. 2:30. Okay. Yes.
46. So if I may please your lordship, my lord, quashing of the entire criminal proceedings, my lord, the informant and the father are present.
47 is admission.
47 my lord already admitted my lord. Victim my lord filed prefer already admitted my lord. They have for appearance cases posted to today my lord. They have already appeared.
They went to appear. Release it for hearing. 48, 47 release it for hearing. Okay.
48.
48. Yes.
The appellant has been convicted for the offence 458 and 371 of the IPC.
Already admitted.
Are my lord?
Admitted.
No
Appeal
matter.
is admitted or not?
No admitted, my lord.
Why it is not admitted?
The delay for 223 days, delay has been found on my lord.
Delay condone.
My lord.
Already delay condolence is 7.
Okay, then delay is condone, then it admission. This is the next week for admission. Is it against the conviction by the
Yes.
accused? Accused.
Yes,
By the accused. Admit call for TCR. Poxo is not there, na?
No, my lord.
Call for TCR. Release the matter for hearing.
49.
And realization of fine, if it all there. Okay.
Rejecting the
Domestic violence. Domestic violence act. I'll issue notice.
Very peculiar case, madam.
I'll issue notice. Domestic, see, matrimonial, domestic violence.
What has actually happened in this case, after the closure of the divorce case, after she has received 15 lakhs, but she has not disclosed before the family court that she had filed a case 5 years prior to the divorce case before the magistrate. After taking the money for her and for the
Divorce is done.
Divorce is done.
Then issue notice. Issue notice in the meantime. Divorce you have filed. Okay, in the meantime, let the petitioner move application before the court of SDGM Baleswar in CMC number 77 of 2019. If such application includes, same shall be considered. Release the issue notice. Release the matter after 1 week. After 1 week. Notice. Take out the notice.
Notice will be.
Take out the notice. Opposite party number 2. Opposite party. Number 2. Yes. 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 50? Yes. All 50. 44. 44. Let him come. Let him come. Yes.
Item 50.
Yes. Pass over.
51.
That item 51, letter was issued to the IAC as well as SP to give the whereabouts of the applicant. At the time of occurrence, the applicant was residing at Radkala, but his native place is
Somewhere in Andhra Pradesh.
Andhra Pradesh. Therefore, you Lakshmi kindly directly SP Radkala to coordinate with the counterpart of
That was the order passed earlier. How they will get the report? That is obviously they have to coordinate and do it. It is written, submits that the permanent address of the applicant is at Srikakulam and he'll coordinate with the concerned police and give a report. This order was passed long back on 31/7/2025.
My lord.
The Mr. Naik Land Council for the this is 94 appeal. Just imagine who is appearing for the appellant. What is the age of this appellant? Just see.
At that time, 24 years.
At that time means 90. Just see here the final form. Just see final form. The RCD if you see. What is the name of the appellant? Name of the appellant is Ramesh.
Ramesh.
Okay. Just check it up. See the chart sheet.
Yes, of the year 92.
Hmm?
Yes, of the year 92.
Yes. He was 22 years in the year 1992. Now he must be in the 50s. So let us presume that he is alive and proceed with the matter. Proceed with the matter. Who is Mr. Mohanty there? Mr. Mohanty, who has been appearing? None appeared. None appeared. Mohanty. Mohanty.
Amicus curiae.
Consistently since last many hearings, none has appeared for the appellant. And since the matter is the appeal is pending since 1994, I appoint other points of view. The matter is so and so. I can make a security. This matter for disposal. Next week I'm appointing. And next week I'm listing it for disposal. By appointing someone.
Office of Honorable Justice Public Matters.
Just imagine. Okay. What is his name? Avas Manti, yeah? Avas Manti. Avas Manti, advocate.
Engaged as amicus curiae.
Appointed as amicus curiae to assist the court. Copy of the order along with the appeal memo and all, we supplied to Mr. Avas Mantia, lease the matter for disposal, lease the appeal for disposal next week. It's made clear that no adjournment shall be granted in the date appeal. Yes. 94 matter, how much? Yes.
52.
52.
Who, that is the array of 2 years.
You are appearing?
Yeah. Well, now the accused will be around 70 years.
70 years.
Yes, my lord, at the time of judgment, it is the 42 years. In the 97.
2 years.
At the time of judgment,
97 and 42 years.
97.
So now must be 70. In the year, when the judgment of the impugned judgment, when the I'll get a report first. Let us get it.
And second thing,
report
is suffering from actually a psychic.
No, there is a report. Already there is a report that he is alive.
No, he is alive. Psychic report. And second thing, he was a teacher. Here, because of his honesty and truthfulness, sometimes in protest, he used to have some litigation with some believers. And in this process, my case is that he has been falsely prosecuted in this case.
Yes.
Here, that is my case. And the prosecution case is that there was a quarrel. The injured PW2,
yes,
mother of the informant PW1, she was abused. And she was abused at when she was coming back to her house. The accused, his wife and others who are not implicated as an accused, even though allegations are there, I don't know why my case is that the investigation is completely perfunctory, perverse, and completely concocted one. I will submit it in the record.
Yes.
They are not implicated and they are not charge sheeted. Then the appellate assaulted the son of the PW2, the injured.
Yes.
When the PW2 went to see, she was given a blow by a taboo.
PW2.
PW2 was given also by a taboo.
Okay.
And which is self-contradictory, inconsistent, so far evidence is concerned. And seizure, including the chemical action report, is not there. The IO is saying that because I did not feel it to send it to chemical action, I have not sent. And second thing, here the medical examination, the doctor who was examined was not posted in the hospital they had been. On that day, the doctor was not there. The doctor is saying that I was giving requisition. The IO is not saying that there was any requisition. Rather, contrary, he is saying that the doctor was absent. So entire thing, the entire prosecution case, the initiation of the prosecution case, right from the time of the lodging of the FIR, the prosecution, the PW1 says that he lodged the FIR in the hospital.
Yes.
You also know the medical legal case, the moment the injured comes being with the complaint that he was assaulted.
FIR is to be reached.
First, this is not there because the doctor himself was not there.
Yes.
And second thing, they have concocted, the PW1 says that he lost the FIR in the hospital.
Yes.
Whereas the IO says that the FIR was lost in the police station.
Police station.
So here the entire evidence is recorded in the plain paper. There was no hurry, there was nothing. And that itself shows this is a concocted case.
Who is the victim? Injured.
PW2.
Let us see the PW. Come to PW.
PW2, 3.
PW2 or 3?
Yeah.
He is the informant also.
Mother of the first injured.
Now who is the injured?
2 are minor.
2. PW2. Let us read PW.
PW2 and 3.
I know the accused dog and the took this 1994. That is part of the house. I know the accused in the dock. The accused took place, the occurrence took place on 12/9/94 at about 8:30 AM in front of the house of Bhagwasa and Kopondusa. Here, though the prosecution case is that there are a number of houses because in the village, not a single eyewitness has been examined. The IO says that I have examined, but he has not charge sheeted, neither prosecution has examined. Not a single eyewitness, all are related. Yes. In front of the house of the Bhagasa and Gopabandhu Sahu, at the time of this occurrence, I just returned from the tank after taking my bath and found that this is not ballot, this is, the PW3. This is the injured.
PW3.
PW3 is the mother, PW2 is the also injured. Well, let us see the evidence of PW2 also. Because
Two. He is not injured according to you.
he is also injured man.
2 and 3 both are injured. PW 2 and 3. Injured. Yes. Read it.
I just returned from the tank after taking my bath, found the wife of the Gondaram, the accused Gondaram and his sister were abusing my mother and were chasing them. And my brother was taking my mother towards our house. Since this, I forbade this accused, his wife and his sister, and they went to their house. After they left, I was asking my mother about the cause of the quarrel. And at that time, accused coming from the back side dealt a blow on my head on the right side, and receiving the blow, I fell down on the ground, sustaining bleeding injury. When this accused was trying to deal with another blow, my mother covered me of bleeding over me. The accused then dealt the tabli blow on the back of my mother. After the blow was dealt on my mother, I became unconscious and I regained sense in Bongomunda Hospital. Police came to Bongomunda PSC and examined me. I had narrated the incident. It is contrary to the so far the IO evidence system. Incident to the police. I had in my body one chodi, one lungi and one towel. When I returned after my bath, my towel was seized by the police at the hospital. My lungi, in which the wound of my mother was wrapped, was also blood stained and seized by the police in the hospital.
After receiving the
treatment in Bongomunda Hospital, myself and my mother was shifted to the Khariar Mission Hospital. This is there is no legal evidence for this. Neither of the PSC and not the Khariar, because that nothing has been seized by the IU.
Yes.
Myself, my mother went the paid ticket or the Khariar hospital treatment, nothing. Myself and my mother went was shifted to Khariar Hospital for about treatment. I stayed in the Khariar Mission Hospital as an indoor patient for 30 days and my mother stayed there for 23 days. At about 9 AM, police had asked me about the incident at the PSC at Bongomunda. At that time, my injured mother had already regained sense. Receiving blow on my head, I fell down on the ground in front of the door of Gopabandhu Sahu. The place where I and my mother fell down, receiving blows in the adjacent to the village. To the east of that place where we fell, receiving blow, is the house of Gopabandhu Sahu. To its west, there is village road. The village road adjoins the place where the occurrence took place, and we fell down. To the north and south, there stretches the village road. The distance of my house from the house of the Bhagasa would be around 100 to 150 meters.
What is relevant you want to point out?
Well, these are all the people who are present.
You want to say that the other people were there?
This is the examination. Prosecution has examined.
Yes.
The prosecution starts thereafter.
Yes.
Here, before what happened, my lord, on the day of hearing, the advocate for the accused was absent. He asked for some time to engage another advocate. The trial court rejected it and appointed his own advocate. Within 5 minutes, they started examining the cases. This is how it happened, virtually in absence of the law of the petitioner. Then petitioner approached this honorable court. Then the honorable court allowed the revision and directed to recall the witnesses. But by that time, this examination had already over. The examination in chief, the matter which could not have been brought to the record by your suggestion or this etc. This was already over behind the back. I was only given the permitted that within the criminal division, this honorable court allowed to recall and cross-examine the witness. So there was virtually no proper opportunity.
So page 50 says on recall.
My lord.
On recall, he was cross-examined.
My
Yes.
lord.
So when recall was there, so actually my lawyer was not there when the examination in chief was going on.
Yes,
Though technically there was a lawyer, my application was rejected in 5 minutes.
I
he has-
understand, I understand.
That should not have been.
Yes. While I was talking to my mother, anything relevant here, page 50, cross-examination?
My lord, cross-examination, it is there. Further, your lordship can see page 48.
Yes.
At about 9 a.m., the further cross-examination will be, I think it will be before that 48. At about 9 a.m., police had asked me about the incident at the PSC Bangomunda. At that time, my injured mother had already regained sense, receiving blow on my head. I fell down on the ground in front of the door of the Gopabandhu house. The place where I and my mother fell down receiving the blow is adjacent to the village road. To the east of that place where we were receiving the blow is the house of Gopabandhu's house. To its west where there is road. The village road adjoins and the place where the occurrence took place, we fell down. The north and south of the stretches are village road. The distance of my house from the house of the Bhagasa would be around 100 to 150 meters. The tank where I took bath situates in the eastern direction of my house. If one has to come from the tank to my house, he has to come to the house of this accused. Adjoining the house of the accused, there is Bhagbat Mandir and the house of Khirendra Sahu. The house of Khirendra Sahu situates in front of the house of the Gopabandhu Sahu, thereupon by road, intervening the road. In the village road, at the time of occurrence, there were about 100 persons, as it was a day following the Nuakhai, and the day was a leisure day.
There are 100%.
100 persons. There were not a single witness has been examined. Neither the prosecution has given reason
Yes.
why they are not examined. I did not mark the face of the persons because I was busy in specifying the matter and taking back my mother to the house. I cannot now recollect to the in the chodi I wore and the blood stain. Standing near the legs, my mother, who was leaning over me, this accused, dealt a blow on her back. The wearing lungi of mine, which was taken by tied on the wound of my mother, was already untied by the time I saw my mother in the hospital. I cannot give the size of the tabli by which the accused dealt blow to us. After receiving the blow on my head, I fell on the ground of my back. With this, the accused dealt the blow on my head. I was standing near my brother and mother. It is not a fact that neither myself nor my mother was attended at Khariar Hospital. Police asked me about the incident in the hospital at around 9 a.m. on the date of occurrence. It is not a fact that I have not stated before the police that I, on arrival after the bath, saw this accused Gondaram, his wife and sister, abusing and chasing my mother. It is not a fact that I have not stated to the IO that when I forwarded Gondaram to his wife and sister went to their house. Because if all were there, all should have been implicated in the case. If proper investigation would have been done, the truth would have been come out whether they were present or not. It is not a fact that I have not stated before the IO that when standing near the house of the Gopabandhu's house, I was asking my mother about the cause of the quarrel. Came and dealt blow from my backside. It is not a fact that I have not stated to the IO that when the accused was attempting to deal
These are all suggestions.
Yes.
Come to PW3 now.
My lord.
Let us see PW. Read the cross-examination also.
Evidence of the IO cross-examination will not make to your
Let
lordship
us let us read
Yes,
PW3 thereafter IO.
Yes.
Yes.
I know the accused in the dock. The occurrence of this case took place during the Bhadrava on Monday, which was a day following the Nuakhai. On that day, at about 7:30 in the morning, I had been to the house of Bhagasa as he was suffering from fever, and I went to see him. When I this Bhagasa, my lord, your lordship can see. This is this very relevant witness, but he has not been examined.
Bhagasa is not examined.
Not examined.
Not examined. Right.
Which is where they occur, actually the prosecution story starts. I went to see him. I just entered the house of Bhagasa, accused his wife and his sister started abusing me in the filthy language. I protested, telling to this accused that he was adduced that he was an educated man and why he was using in such filthy languages, and without listening to my protest, they again started accusing me. My son Kishore, the one came, the informant, was taking me to our house. When my son Kishore was taking me to our house, my son Baba Pidu came there after taking bath to the from the bath in the tent. My son Dhoba asked this accused, addressing him as Koka, not to quarrel and go back, and accordingly this accused with his wife and sister returned back to their house. After the accused, his wife, sister left, my son Dhoba asked me to the reason for the quarrel and abusing by, this is contradictory to PW2, abusing by the accused. Before I started narrating the cause, this accused Gondaram came and suddenly dealt a blow on the head of Dhoba
That is
by means of
PW2,
a tabli
by
and
means of a
sustained
tabli.
injury.
That is
Dhoba fell down dead on the ground. When I leaned over the body of my injured son, this accused Gondaram dealt the tabli blow on my back and dragged the tabli, putting his leg on the waist, and I lost my sense. Each stage they have developed the case from the prosecution.
Yes.
Starting from lodging the affair.
PW2 says that only one blow was given.
Wow.
He says that,
That is there,
blow was
but-
given and it
But
dragged.
the initiation, the very beginning, the initiation of the case is also very,
Yes.
perfunctory.
Apparent improvement.
Yes.
Apparent improvement. Yes.
No, one is saying that we lost the FIR here, and the another is that the FIR is at police station. Third thing is that FIR has been sent to the court in a belated time on the ground that there was no staff. So all these purposes, there is everywhere there is all illegalities. There is very weak explanation.
So let us come to now
Yes.
PW, the IO.
IO.
He is the main witness
Yes.
for you. And who is doctor? Who is doctor?
Doctor is PW
9. PW9, doctor. Huh?
Let me first IO malware, that is better.
IO is PW?
IO
10.
IO PW 10, let me place the evidence because the entire thing of the concoction will come out from his evidence.
Yes.
On 12/9/94, I was attached to Bangomunda PS OIC. On the day at 9 a.m., complainant Kishore Sahu presented a written report. He is saying that he has reported the
PW1. PW1.
before me, and he has reported and revealed cognizant case of 307 OIC such and such and took up investigation. This is a case written. This said written report of the complaint exhibit 1, and wherever IO is PW1 is saying that he has lost the report on receiving the information. Police came to the hospital. He lost the report in the hospital. The took up investigation. This is a time. This is the said written report of the complaint exhibit 1, and exhibit 1/2 is the endorsement of the with the signature of the report. Before taking the investigation, I drew a formal affair. This is the formal affair such as. During course of investigation, I examined witnesses, issued injury requisition for examination of the injured persons, Dhoba Sahu and Lakshmi Sahu. Exhibit 4/3 is the requisition in respect of the injured Lakshmi Sahu. Exhibit 4/4 is my signature. 5/2 is the requisition in respect of the injured Dhoba Sahu. Exhibit 5/3 is my signature there. At about 10 a.m. at Bangomunda PSC, I seized the blood-stained lungi, towel, towel of Dhoba Sahu and blood-stained shirt of Kishore Sahu on production of the Kishore Sahu prepared seizure list and obtained signatures of the witnesses. This is the said seizure list. Exhibit 3, already marked exhibit 3/3 is my signature, is the signature seizure list. I examined both the injured persons at Bangomunda PSC on the same day at about 9:30 a.m. At 10:30 a.m., I visited the spot, prepared the spot map. 11 a.m., I arrested the accused Gondaram Behra in his house, Bangomunda, and interrogated the accused in presence of the witnesses, and he gave information about the concealation of the tabli, the weapon of offense in the cows and the shed under broken wall. Exhibit 10 is the relevant portion of the statement giving information regarding the concealment of weapon of offense. I recorded the presence of witnesses. Exhibit 10/1 is my signature. Giving the statement, this accused Gandaram led me and witnessed to the cow, and he pointed out the place where he kept concealed the weapon of offense, tabli, and I recovered the same and seized under the
27 is also employed. Huh?
My lord.
Section 27.
This was not, nothing was sent to the chemical license report to confirm. This all whether there is a blood of the accused person or not,
Yes.
injured person or not.
Yes.
This is the set seizure list exhibit 2 and marked exhibit 2/2 is my signature. The witnesses were also present, signed in the seizure list. After I read over and explained the contents of them, is the signature of seizure witnesses Tapi Sahu, which he gave in my presence. MO1 is the set tabak which I had seized in the instance of this accused. I thereafter examined other eyewitnesses of the witnesses of the occurrence, namely
All the names are given.
yes, sir. On 13/9/94 at 10:30 a.m.
And out of these named people who were examined?
Bhagasaw is not examined.
Yes, Bhagasaw is D-1.
Huh?
Bhagasaw is D-1. I'm the defense exam.
The defense examined.
D-1.
DW1, huh? And Kalpendra?
No, they are not examined.
Not examined.
And another interesting thing that when he had been with the
Manbodh
city,
Sahu?
he had been with the city. What was the reason not to record it in the city? And why he recorded in the plain paper? Your lordship knows out of experience.
Yes.
The recording in the plain paper itself is a vital.
Just check it up out of these named witnesses, those who have been examined or not. Just tell me the witnesses' name. Yes.
Case 13, your lordship can you see?
So he will do it. Let us read it.
Yes.
Meanwhile, let him check it up.
The D-1 page 84.
No, Bhagasaw is
You
not
check it up, the name, and tell me from the last page, page 27, just see who all are the witnesses. 26 paper book. Just read, see the name and tell me.
This is occurrence.
10 witnesses have been examined.
My lord.
This much you can do.
Rajendra Saraf is examined.
Madhav is not. Rajendra Saraf, Harapriya.
Harapriya Patra is not examined.
None of them is examined.
My lord.
Kalpana Saraf.
Bhagasaw is not examined.
Kalpendra is examined.
Bhagasaw is D-1.
Kalpendra PW4. Kalpendra is examined.
My lord.
Kaplan is P-4.
4, yes. Madhav? Manbodh.
Rajan?
Not examined. Rajendra Saraf? Examined?
P-5,
yes. And Harapriya? Not examined.
Harapriya not examined.
Bhagu Sahu examined is DW1.
D-1.
Raivari Sahu?
9.
Not examined. Okay, proceed now. Oh, yes, enter. Yes.
I forwarded the accused to the court in custody along with the accompanying report. Both the injured who were not the first instance treated at Bongomura PSA were shifted to the Career Mission Hospital for their further treatment. On 8/12/94, I received the X-ray photograph plates of both the injured. On 9/12/94, I produced the X-ray plates before MO Sindekala PSC for his examination and opinion as to the nature of the injury with my requisition. This is the said requisition issued by me by Exhibit 11 by 11/1 is my signature. There, this is the signature for X-ray form. This requisition is for X-ray man. Your lordship may kindly remember this. This is the said requisition issued to a surgeon, sir. On the same day, I also produced the weapon of offense, that is the tabli, before the said MO with the requisition seeking his opinion as to if the injuries on both the injuries from the whom he examined would be possible by this.
Page 77 is relevant. Read the top. Page 77.
Manner.
The top. Top.
Manner.
I had kept the tabli.
Tabli wrapped in paper till they dispatched to the court.
Read it.
When I seized the tabli MO1, it was stained with the blood. Since I did not receive the X-ray plate of the injured, I had to get opinion of the doctor regarding injury and their nature. I did not send the tabli.
I did not send the tabli to the doctor for examination.
And for examination.
And opinion.
Not the fact that tabli was not hotel recovered. For that, I did not send it to the doctor. It is not the fact that the MO I was not sent to the doctor of his examination of opinion. Since the tabli was sent at the late stage to the doctor for his opinion examination, I did not send it for chemical examination.
Yes.
This is baseless thing.
Yes.
You know, chemical examination.
A slight blood stain.
Slight blood stain.
That was
Even
there.
if it is not there, my lord, still the chemical examination can find.
You have to explain this.
That stain, there was might have been deterioration, might have been his presumed. Deteriorated by
It's not a fact that
it
these
is not a
MOs
fact that these
including
MOs,
blood
including
stain
blood
cloth
stain clothes, were not
were
at all
not at all
existed. I had not sent them for the chemical examination.
None of the MOs were sent to the
No.
chemical examination.
It was not sent to the
The
court.
wearing
to
sir is
the trial.
objected
It
by
was
and
brought to
proxy.
the trial only.
This is so and so job.
It was brought in during the trial only.
Hmm.
In the previous paragraph, he has stated. On 12/9/91, Dr. Bhagwan PSC was absent. Your Lordship can see. He was absent and he has not sent requisition to any other doctor to examination.
Right.
And how could the patient be examined and their bedded ticket is not seized? I have not examined any doctor, Your Lordship can see, but a doctor has been examined by the prosecution. I have not examined any doctor or staff of Mission Hospital Khariar in connection with this case. I have recorded the statement of mutation or 161 statement in plain paper. There is no reason for it. That itself shows that this is a afterthought and a concocted case.
Yes.
When receiving the FIR at police station, he had been to the hospital along with the CD. There was no reason why he will not record it on each
Yes.
continuous page.
Yes.
I had examined PW1 Kishore Saud during the course of investigation. He has not stated before the that accused Gondaram and his wife chased me and his mother. He has not stated before me that his brother Dhoba Saud, he himself and his mother Lakshmi were standing in front of the house of Gopal and Dhoba was asking his mother about the cause of quarrel. Kishore Sahu has stated before me that after Dhoba specified Gondaram went to his house. So your Lordship can see before the alleged assault made, which is in developed case in the by the witnesses PW2 and 3, he went back to his house. He has not stated before me that Gondaram and his wife both went to his house. I had examined Dhoba Sahu in connection with this case. He has not stated before me to have seen Gondaram along with his wife and sister quarreling with his mother. The very prosecution, initiation of prosecution case itself is false.
Yes.
And chasing to assault her. He has not stated before me that when he asked Gondaram, his wife and his sister not to quarrel. They went back to their house. He has stated before me that in front of the house of the Bhaga Sahu, he was asking his brother Kishore and Lakshmi and was taking them to their house, where the appellant was not there. He has not stated about the standing in front of the house of Gopabandhu Sahu. He has not stated that when the accused was trying to deal second blow on him, his mother leaned over him and the accused dealt a blow on her back. I had examined PW Lakshmi Sahu. She has not stated before me that when she was entering into the house of Bhagav and Sir Gondaram along with his wife. So how important this Bhagav is, my lord, from the beginning to the end.
You examine as a DW1.
Yes, and absolutely no out of
He naturally he was present there.
present there. Everything starts.
He
from
would have
this-
been a star witness for
Star,
that.
yes, exactly. And there is absolutely no reason, explanation is there. What to speak of iota.
That
nothing.
you encase the situation, you examine as a DW.
Yes, ma'am. That we'll see. Stated Bhagasahu, Gondaram along with his wife and sister abused her. So he has only stated that Gondaram wife sister abused her. She has not stated about the asking accused. Gondaram addresses him and Kaka not call and return. She has not stated before me that the accused Gondaram after dealing blow on her back by the tabli, forcibly dragged out by tabli, keeping his leg on the right, west. I had examined PW Rajendra Saraf. He has not stated before me that when he arrived near the spot, he found Dhoba asking his mother and brother Kishore about the cause of the quarrel. I had examined PW1 Kalpendra Saraf. He has stated about seeing Dhoba Sahu, Lakshmi Sahu, Kishore Sahu in front of the house of Bhagwasa. I had examined single witnesses Parameshwar Sahu. He has
Now 79 para 18.
My lord.
79 para 18.
My lord.
Yes.
Para 18, right, ma'am.
Yes.
In fact, the further process.
You read para.
Yes, she is tabli.
I read it.
Yes. His tabli was stained with blood. Wearing abrasal of PW1, 2, 3 were also stained with blood. I have seen that blood stained tabli and blood stain wearing abrasal. I had not kept those under sealed cover. I had not kept those under sealed cover. After seizure, the seized article were kept in PS Malkhana. I have not sent the seized article to the court of JMFC Katabanji thereafter soon after the seizure. I had not sent those till submission of charge sheet. I have not sent any of the seized articles for chemical examinations since I felt not necessary. It not necessary. I sent injury requisition to Santala PSC as then no doctor was available for Bangomunda Hospital. I cannot give the exact time and of issuing requisition, but after 9:45 AM on 12/9/94, Sidekala was about 5 kilometers from the Bogomunda. Since it was not required, I did not divert my investigation on the discrepancy in the injuries of the injured persons mentioned in the injury.
Again, page 81, para 25.
Minor. Yes, I cannot say if
Kind of
injured persons were also treated at Kottamaji CSC. So this is the vital.
Just see what kind of investigation is this and read further.
The admission of Career Mission Hospital and the bedded ticket of the injured persons I have not seized. I have not sent the X-ray plate to any radiologist for the.
Nothing is done.
Nothing, my lord. The very initiation of the prosecution is false and self-contradictory. If your lordship will see the IO, if evidence of PW1, he has stated that he has given the FIR at hospital. So where is that FIR? So beginning to the maintaining the investigation, recording the statement of the witnesses, and the further not the prosecution witness says that there was full of blood on the spot. He said that there is police saying that there is no blood on the sir, he has not seized.
Then primarily what you are trying to say is, first of all, the registration of the FIR itself is doubtful.
Yes,
the timing, place of registration of FIR is doubtful.
Right.
First. And second is, the entire investigation is bossed up because the IO has not done anything which is required to
Not
be
done
done.
anything. And the perfunctory is done that he has recorded everything plain paper without any reason.
And reason.
Even though he had been to the hospital with the case diary.
And third one is the weapon of offense and other articles which were seized where the blood stain was there. It was kept, not produced before the doctor, not examined.
Not examined.
Not
And
examined.
even at the time of charge sheet, it was produced at the time of trial only.
Trial only.
Yes.
He says that he is not produced before JMFC.
Yeah.
He says in para
And
80.
whether the blood stain
Para
everything
80.
was.
Are you noting? No. Noting? No. Note down. Para 80, na? Para 80 I cross examination. Okay.
And
Thereafter,
that could not
para
be
20,
established that
para
the-
25, he says that neither the bedded ticket nor the X-ray plate, nothing is seized. Nothing.
Not the examination. They said that they got examined in the Career Hospital. There also
That
they have
also
got
he
nothing has
did
been
doubt.
seized from there.
Yeah.
So completely baseless and concocted case.
And when IO says, I cannot say the injured persons were also treated in Kantavanji.
Yes.
And what the PW1 says, where he has given the report.
Yes, ma'am. Your lordship.
Let us see. Kantavanji or
Yes.
Kariyar?
No, PSC in the hospital. He is saying that he has lost the affair in the hospital. Yes, Your lordship, can you see page 40? Cross examination.
Para 2. No, para 2 you read first.
My injured brother had told.
No, para 2 you read first.
Madam.
Para 2, page 40.
Madam.
Last paragraph.
Immediately after the incident, my friend came and took my injured mother and brother to the hospital. The occurrence had been witnessed by the Haripriya
Don't so.
Patra Rajendra Sir.
Leaving my mother and brother at.
I lost the FIR at the PS.
I went to Boramunda police station to report the matter. I lost the FIR at the PS, and this is the said report to exhibit so and so, so and so, so.
Madam.
He says that the police station he has given the report.
Madam.
Yes. Next.
Your lordship, can you see this cross section, page 43.
Yes. Yes. Yes.
The Suresh Kumar Sahu referred paragraph that on the accused and his wife were quarreling with my mother. The accused and his wife were quarreling with my mother at the village road between the houses of Ananda Sahu, Bhagat Sahab. From that place, an accused and his wife chased me to the distance of 30 to 40 cubits towards the north side. At the time of occurrence, many villagers were present, but I cannot name them excepting Suresh Sahu and myself. My elder brother Dhoban Sahu reached out near the place where I was chased by the accused persons and his wife. On the day of occurrence, the accused and his wife did not pick up quarrel with me and elder brother PW2, but they abused me. It is another contradiction. While the wife of the accused was quarreling, accused Gondaram went to his house. I cannot say that for about 1 minute or 2 minutes, the wife of the accused abused me. I have passed +2 examination. After the occurrence, myself, my mother, and my elder brother Dhoba went to the house of my uncle Ananda Sahu. We stayed there for 5 minutes. It is a fact that I have mentioned in the affair that before the assault, my brother, my mother, my mother
by the accused.
Huh?
By the accused.
Accused took my mother to my house. I took my mother to my house. The accused gave one blow to by tablet to my elder brother Thoba. Also gave one blow.
Hey, what is your case? The FIR was registered where?
Look, somewhere he's saying that it is FIR at the
Hospital.
the
But PW1 says, at para 11 also in the cross examination, at the police station, I wrote the FIR and presented it to the Thana officer.
And the PW 10 I was stated that the
Thana.
there was Ishwar Sahu present and a written report before me and as the report received.
But where from you got that it was written in the hospital?
somewhere I have read, man.
Is the period undergone by this man?
No, that will not. The whole point is that may cause inconvenience so far the getting pension, etc. will be.
Is he working?
Yes, he was a teacher. Yes, now he must have retired now. He is a teacher. That was no, this is a thoroughly concocted case, my lord. This is the whole point is that it's a village quarrel.
But the only problem is that there are 2 injured. The evidence of 2 injured are consistent. And is
evidence
corroborated with PW10. How will you get over that?
No, because there is no injury is nothing excepting oral evidence. There is no corresponding medical evidence. And the medical doctor
PW10, just see.
The doctor who says he was not the authorized doctor.
Just see who is PW10.
The doctor who has said that is not the authorized doctor as per the IO. The doctor was absent. How could he examine under what authority?
Dr. PW9.
Yes. He was not their doctor. Because he called, he came. So he must have been a
no, he was posted in the hospital.
No.
He
was not
another hospital for control the epidemic.
No, come to page 71.
71.
He was not there in the.
Come to the page 71. On 12/9/1994, I was medical officer, MO.
Yes.
आपको सिंधल लिखा PhD. On that day, I had come to the village so and so.
He could not have come.
The epidemic. Since on that day, the MO attached to Baramunda PH was absent, being called by the relatives of the injured persons.
How come and how he
came to Baramunda PH and there on the police requisition,
examined one Lakshmi Sahu, wife of Ghostav and Bangamunda and found the following injury.
You found and he was not a regular doctor there.
No.
Show me the requisition.
No requisition.
Show me the requisition, police requisition.
No requisition.
Which exhibit?
The very injury certificate, the police himself is saying that he has not seen the bad ticket also.
No, he has, particularly because of the manner in which the investigation is done, he says that he is a stranger kind of person. He says that I was attached to some other doctor, PhD. I had gone to that village for some epidemic control thing. That time the relative of the injured have asked him to do it. And on the police requisition he has done. Where is the police requisition?
No. That is not.
Exhibit is not even exhibited.
When I was evidence I was placing, I was pointing out that he has not given any requisition for the doctor. And that is why probably he has not seen the better ticket. He would have seen the better ticket. And these people are saying that they have given statement in the police station that regarding serious contradictions in the evidence, recording of statement also. Someone is telling in the police station, someone is telling in the hospital. And there is no match of the blood also. This all manufactured a concocted case because these people are implicating the appellant at the behest of some person with whom the petitioner has got civil dispute.
And you have not examined Courier police station,
Madam.
Courier hospital doctor of Courier hospital.
Neither they see nor they examine. You'll also kind of see the evidence of the PW in DW1 also. DW1 says no occurrence took place. Page 84. I know the accused got around.
See, Lakshmi Sahu, PW3 was this PW9 has referred PW3 to Titlagarh subdivisional of hospital, and he was taken to Courier. Just see 73, page 73.
Yes, that is.
Suspecting the fracture in the or the internal injury, I referred injured Lakshmi Sahu to subdivisional hospital Titlagarh. And you have said taken to Courier. And Courier, no doctor, no medical staff of Courier was examined. Better ticket is not seized. Where is requisition? Show me police requisition. How do you know that he PW9 was a doctor? He is not attached to the police station. Sorry, hospital. How do you know?
They are stating that for the control of epidemic, he has, may I read?
I read it already. He was there in that village for control of epidemic. Some evidence you have to bring. Merely saying that anything anybody can say. The defense can say that he is not even a doctor. What will you how will you answer? He is masquerading to be a doctor, but he is not a doctor. What will be your answer? Then you have given requisition. Show me the requisition.
Exhibit 12 is the requisition for the assumption of the which one?
12.
The answer should be to the question. My lord asked the question, show the requisition to the doctor, and you are answering that the requisition to the.
No, this is tabli and all. No, requisition given by the police in favor of PW9 to examine because he was not attached to that hospital. He happens to be there for some work. He says that for epidemic purpose. The very fact that whether he was a doctor or not, how would you know? Merely is he writing doctor. He may be a fraud doctor. How do you know? You have to establish that yes, he was there for epidemic purpose. Or requisition has been done. Where is the requisition? Requisition, there is nothing.
There is no requisition. At the time of placing the evidence of PW, the IO I brought to your lordship notice.
Injury report take it. Injury report take it. If they would close the mark, without objection,
Who took him to the hospital, they do not know. ताको इंजोर फिजर को नेला किए केमती की नेला कोर्ट को नेला डॉक्टर कहले डॉक्टर को जी मते के जने डाकी देला. There are a lot of infirmities in the to finding out the truth by the prosecution, and the prosecution witnesses have themselves have become overzealous by developing something in each stage of the trial.
तो फिर difficulty है पीछे.
First duty that if at all he was anyway competent, he should have intimated to the police.
Kindly see exhibit 5/2. See, this is the requisition. This requisition was given to the medical officer Siddhi Lekha.
That is Bongomunda, who was not present. Doctor of the PSC2 where they went to for treatment was not present, not there.
And exhibit, if you see exhibit 4 also, exhibit 4/3, the MO, this is also requisition to MO Siddhikala. And there is no MO is not done. Some stranger has done. But the medical officer attached to that PSC had not examined. Somebody else has examined. This is the exhibit. On police requisition, he says in page 71, he says that I came to Boromanda PSC and there was
Police request.
there on police requisition, I examined.
Yes.
And so and so. Police requisition is exhibit 3 insofar as Lakshmi examination. 4/3. And this requisition is done to just see MO Siddhikala.
Date also 12/9.
12/9. Siddhikala PS. But he was not a doctor in Siddhikala. Siddhilekha, whatever.
And look,
He was posted somewhere else.
Paragraph 1 में से कोई चीज doctor, page 71, being called by the relatives of the, he has not come for the accused.
Siddhikala.
Being called by the relatives of the injured person, I came to Bongomunda.
This requisition is MO to Siddhikala
Yes, I am
and to be conducted in Boromunda.
In paragraph 1 of page 71,
Boromunda is coming under Siddhikala.
No. Being called by the relatives of the injured person, I came to Bongomunda. Bongomunda PSC is different. Sindhikala
He
is
is attached to Sindhikala PHC, but at that particular time he was present in Bongomunda.
How will I? Where from I'll get it?
I'll just read it. I'll just reread it.
page,
On
paragraph
12
1, you will not see. Paragraph,
I'll just reread the entire sentence.
paragraph 1.
On 12/9/94, I was medical officer of Sindhikala PHC.
Siddhilekha, whatever.
Sindhikala.
Siddhikala, ठीक है.
On that day, I had come to village Guriapadar under Bongomunda PS jurisdiction to control epidemic. Since on that day, the MO attached to Bongomunda PSC was absent, being called by the relatives of the.
Relatives,
Sir, I'm just reading. Called by the relatives of the injured person, I came to Bongomunda PSC, and there on police requisition, I examined on one Lakshmi Saw and the Duba Saw.
No.
They kindly see the cross examination part that corroborates. When the relatives of the paragraph 6 solution, when the relatives of the injured went and called me from village Gudiapada, they told me that there was a serious patient in Bongomunda hospital and requested me to come and treat. They also told me that the injuries were inflicted by Tabli and a serious one solution. I was giving treatment I stitched the injury of Lakshmi Sahu immediately. When I was giving treatment, the police arrived there in the hospital. And the
But it will
requisitions
be
are there.
treated as a medical examination at Bongomunda or Sindhi College.
He was attached to Sindhikala, but the entire thing has been done under
But the
Bongomunda
requisition is
police.
made to Sindhikala.
It has to be because he was the treating doctor. He could have given a opinion on worship because he has seen the
Requisition is
patient.
made to Sindhikala.
So there are three requisitions. First of all, exhibit 3 and 4. This one, the 4,
4 and 5.
4 and 5. This is the primary requisition which was given by the police to the MO. Thereafter, he was since their fracture was there, the X-ray plates were placed
And
between the
this doctor who has
Yes,
done
sir.
it, PW9,
Yes, Lordship.
refer Lakshmi, PW3, to Titlagarh.
Titlagarh, but
And how she reached in career, and nobody from career hospital is examined.
Your Lordship,
Bedhead ticket is also not placed.
Your Lordship, for that reason only, Your Lordship, may kindly see the paragraph 4 and 5. For that reason only, he was again placed another requisition and made to this medical officer, to which he opened. May I read it? I had referred the injured Lakshmi Sahu to subdivisional hospital Titlagarh for a further treatment, but the relatives of the injured
Was he
Lakshmi.
taken to Titlagarh or not?
No,
Tell me.
he was taken to Courier Mission Hospital. Your Lordship.
And bedded ticket, no, nothing is placed on record.
Your Lordship, I'll just, no, the X-ray photographs and the other reports are there.
Nothing is placed on record. That's what the case is.
Exhibit 5.
The medical legal case, how on earth a doctor of one hospital can come to the another hospital for treatment by calling by the
See,
patient?
this is very hot stuff.
Very hot stuff, exactly, man. Your lordship rightly used the word. Very hot stuff, concocted and very casually it has been manufactured at the behest of some person.
Exhibit 7 is the X-ray plate of
The IO's
Goga
contract
Sahu.
clearly shows. And why you will not record in case diary page by page?
Chala, you give written submission.
Not sir. No. There are judgments your lordship knows. This case diary is a vital thing. It has to be to find out the blood your lord criminal case, earliest FIR, speediest investigation and proper investigation. And case diary it has to be maintained page by page, so that the truth will come out to the court.
So we'll refer to the case.
Access to the court.
Your Lordship, may kindly give me Passover or adjourn. I'll give it.
No,
to
no,
you.
I am reserving the judgment, you said.
One Passover after lunch, so that we can place the relevant.
45 minutes you have wasted on this.
One Passover. One Passover.
What do you want to show?
So I'll just go through the case diary and the requisition part and the
At the end of the
evidence
board. At the end of the board.
Yes.
Let him submit. Your lordship may permit me to go.
Yes, yes, you can. You have done it. Let him clarify. Yes.
That order. There's a vakalatama from the victim as well as the legal.
Which item?
Item 32.
Well, I'll just call the password matter.
That has already been ordered. You could give me mark each.
32, huh?
Second part.
Out of 32 की निकला? Let me read out the chart. Your research for here.
Mark is easy.
32, huh? Yes. Yes, password.
Password item. Password item 20.
May I please also? Although this order has been passed in 5/8/2024, there was a direction that since the trial has been started and the victim has been examined, so I may renew my prayer in the learned court bill. But in fact, at that point of time, my lord, the trial has not been started. And para 4 of, I quoted that order, my lord.
You said that they have already been examined.
No, 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 I have not, actually, at that point in time, my junior was there, I told her, pass over.
How will I know it? Now they have been examined or not?
No, yes.
Then do it.
Madam, one eyewitness is there, she has already been examined.
All right,
Yeah.
do it. What is the big deal about it? Yes.
She had already been examined. in
The,
this. And the victim, it is written that it is a case of 302 mile.
By the order dated 5/8/2024, this court, by not inclining to entertain the bail application, relegated the petitioner to renew the bail plea after the material witnesses have been examined. The IA has been filed for modification of the same on the ground that when the order was passed on 5/8/2024, that day, till that day, no witnesses was examined. Learned counsel for the petitioner, however, submits that subsequent to the order dated 5/8/2024, the victim has been examined. No?
Victim, no, my lord.
Okay.
Post-occurrence witness.
Post-occurrence witness.
Witness, her name is my lord Basanti Naik.
Examined.
Yeah.
In view of the same, the liberty which has been granted to the petitioner, petitioner can avail the liberty which was granted to the petitioner by the order dated 5/8/2024 by renewing the bail before the trial court. With this obligation, the is disposed of. Yes. Next.
26. May I please, your lordship?
Yes.
Lordship, in this case, this is a 498 matter. Both the parties are present. The petitioner and the opposite party, they came to amicable settlement. They're filing a joint affidavit. Okay.
What is joint affidavit? Soumya Ranjan Bastia and Sasmita Vishwal. Just ask. Sasmita Vishwal, come this side. Yes, just ask her that the instance of the opposite party number 2, number 4, came to register with the petitioner. The allegation is requiring so and so. The petitioner moved this present petition seeking quashing of the entire FIR. When the matter stood thus, the parties have settled their issue. Notice was issued to the opposite party number 2. Notice was not issued?
Notice was not issued.
The opposite party number 2 has appeared on advance notice. Both the petitioner and the opposite party number 2 conjointly submits that subsequent to the registration of FIR, they have settled their dispute amicably. They have also filed a joint affidavit dated soon, 15/26, entirely applicating as under para 2 and 3. Para 2 and 3. The petitioner and the opposite party number 2 are present in the court. They are being identified by their respective counsel. They have also filed their self-referential copies of the Aadhaar card to establish their identity, which are taken under record. On query from the court, what is the settlement? Where is that lady? Settlement, what is the settlement?
She says that was agreed for 10 lakhs for permanent alimony. She has already got 6 point some odd, and another 4 is yet to be paid to her. That was
4 lakhs you have to pay.
Another 4 lakhs after in the final settlement.
Final settlement
Yes.
when?
So it is already pending before the family court. We have already filed a joint affidavit and it is pending for the mutual.
First motion you have moved.
Yes, you have deposited.
13B
Yes,
you have
yes,
filed.
lordship.
And in the first motion you have paid 6 lakhs.
6.5 lakhs.
6 point. And the remaining 4.5 lakhs?
In the final settlement.
You will pay in the second motion?
Yes.
Right. As on query from the court, the opposite party number
that may be reflected in the audition.
opposite party number 2, the wife submits that in terms of the settlement, she has already received 6.5 years. She has received 6.5 lakh rupees, and the first motion under section 13B of HMA has already been moved, and the petitioner has undertaken before this court that in the second motion, the remaining amount of 4 lakhs?
4 lakhs, only 4 lakhs.
4 lakhs. Total 10.5.
10.5 total.
Remaining agreed amount of 4 lakhs shall be paid. The undertaking is taken on record. And then the basis of the aforementioned settlement terms, the petitioner seeks quashing of the FIR. The opposite party number 2 has no objection to that. No objection regarding it to the
Obviously.
parties are bound by the parties are bound by the settlement terms.
39.
In the event, we'll write down, in the event the petitioner fails to make good the entire payment as agreed upon, the opposite party has legal right to revive the FIR will be revived and investigation in accordance with the law will be carried out.
One more sentence can be added, like both the parties will cooperate for the expeditious disposal of the 13B application. Otherwise, they'll keep on dragging it.
No, then see, there is a cooling period of 6 months is there. They have to move application.
Yes.
That is their outlook.
Yes.
I can't dictate today. Then on that basis, they'll say that High Court has said that the cooling period is gone. So let them do whatever.
Yes.
I said second motion. That's
Second.
their outlook. Yes. Next.
39.
Yes, 39. Huh? What passover again? Second passover. What is this matter is about? What are you taking?
This matter is about,
The mediation is successful.
so twice it has been referred to mediation, but the informant was not cooperating in the mediation. And here the petitioner, some of the petitioners are students, my lord.
So let it be heard by next week on requesting.
Urgent matter, my lord. Only
Urgent
one-
matter 2024 it is pending.
Only one.
What are the offences?
Offences are under section 341, 323, 294, 354, 506 and 34 of 506.
What is the stage?
A charge sheet has been filed.
What student, 56-year-old,
No,
and they are student, huh?
Petitioner, some of the petitioners.
Some of the petitioners.
Yes.
Good see.
Petitioner number 8 and 9. As 20.
45 years, 44 years,
Petitioner number 8
40
and
years, and they are students.
8 and 9. Petitioner number 8 and 9.
There are two, out of 9 petitioners, 2 may be students.
Two are
2 may be
students.
students. We will see next week, huh? Next week. Keep it next week. Yes.
Item 40.
Give a date,
Eight.
21st, huh? Give a date, 21st. 21st.
Interim order to come.
Entry to come. Yes.
Item 40.
Wait, please, enough.
Yes.
So I'm challenging the order of cognizance primarily on 2 grounds. One is no sanction under section 197 CRPC taken prior to taking cognizance. And number 2, disciplinary proceedings on the same ground the government has held that it is an irregularity and not an illegality. Before your lordships open the brief, I'll tell your lordships what the case is.
But you have read my judgment?
Yes, ma'am.
Departmental
I'm
inquiry.
your lordship's judgment,
Yes.
sanction.
Yes.
1966 and in 1960s and 70s, some leases were granted by the state government for agricultural purposes.
Yes.
By 1986, about 50% of these leases were cancelled.
Yes.
But this cancellation.
Who are you? Who are you?
But I'm the additional Tahsildar. The first matter, I'm the record keeper. In the second matter, I'm the additional Tahsildar. Your lordship may have the second matter.
Second material.
Yes, ma'am.
Okay.
Second matter, he was the additional Tahsildar from 2006 to 2010.
Yes. 6 to 10.
Yes, ma'am.
Yes.
2006 to 2011. I was the additional Tahsildar. Was in the 1960s and 70s, leases were granted for agricultural purposes. By 1986, 50% of these leases were cancelled. But these cancellations had not been acted upon by the then Tahsildar. In the meantime, thereafter, 1995, settlement operations under the Odisha Survey Settlement Act were notified in the area. Suddenly, in 1998, they directed the then record keeper to implement the correction of the RO. But in 1998 also, it was not done. I have not even come into the picture. I come into the picture in 2006, and the specific allegations against me are that in respect of these cancelled leases, when settlement proceedings were undergoing, I have allowed conversion of the status of those lands from agricultural to Ghorabadi under the OLR Act. The allegation is that I did not have jurisdiction by virtue of Rule 33 of the Odisha Survey Settlement Rules to make any change in the RO. Now, Your Lordship,
But
kindly have the-
is there any allegation of financial gain?
no allegation of any financial fraud.
Okay.
It is purely in course of my official work, in discharge of my official duties, and there is no sanction taken. May I just hand over?
Show me the allegation in the charge sheet and
I'll first show Your Lordships the FIR.
yes.
Page 26, Your Lordships may have the FIR.
Is there any allegation of manipulation of record and anything?
There are 7-8% there, some of the additional Tahsildar and Tahsildar also.
I will show you Lordship state.
No, what he's trying to say is he's coming, the conduct, the act complained of is coming under the color of duty. So therefore, you should have taken sanction before proceeding. That's what your case.
Absolutely.
He's only on the ground of sanction he's challenging.
And secondly, in disciplinary proceedings, I will show Your Lordship the disciplinary proceeding inquiry. They say that this is an irregularity conducted in thousands of cases by many officers. It was practice and
That would
precedent
be
information.
that would have a persuasive value.
Yes,
for the purpose of that. Let
once
us see whether you
yes,
manipulated record or not.
Yes, Your Lordship may see page 26, the FIR starts.
Come to the charge sheet now. After the
Very well.
investigation, what has come?
Charge sheet starts at
40, page 40.
page 40.
And the real this is.
Your Lordships may come to page
Because
93 onward.
468, 471 and all.
That is there,
Okay.
but there is no.
They have invoked, they have not invoked PC Act.
No, mas, they have not.
Yes.
Your Lordship may have paragraph 16.25, page 93 onward.
93.
Yes, ma'am.
Okay. 3.
Before that, Your Lordship may can also have 16.20.
20.
Page 95.
Yes, investigation reveals that. ADM.
Investigation revealed that ADM Bhubaneswar, while revision case numbers set aside the order of Tahsildar on 2nd April 1984, passed in lease case number this for irregularities committed in the matter of grant of lease and remanded the case to the Tahsildar Bhubaneswar.
That is you. That is you.
No. This is much prior. I come into the picture in 2006.
Okay.
This is much prior, man.
Yes. That is in 84.
84. To take up the
You
case.
came into picture in 2006 only.
2006 months.
Yes. Your portion you show me. What have you done?
Your Lordship may see the last 7 lines. However,
Then the additional Tahsildar Sri Kulamani Naik illegally
allowed the conversion while the settlement operation was in force and without instituting mutation case. Shri Debasis Mohanty is the first person.
being in charge of the record room.
Being in charge of the record room, illegally corrected the Jamanbandi Khata number in favor of the transferee without questioning the illegality of conversion.
What is this illegally corrected? Is there any manipulation on record?
There is no manipulation on record. Your Lordship may see paragraph 16.25, which is directly on the petition.
16.25,
page 93.
Yeah.
I was exercising quasi-judicial powers, Your Lordship will see.
There are direct judgment. If
Absolutely,
you
man.
exercise that Guwahati case, where it says that if you are exercising quasi-judicial authority, if a registrar passes an order, if a quasi-judicial authority passes an order, you can't be prosecuted.
Yes, sir.
Because the revision and the judicial process and the scheme of law is you have to challenge that.
Your Lordship, please.
A wrong order passed by a quasi-judicial authority, no mens rea could be imputed.
Yes, ma'am. Your Lordship may just see 16.25. Investigation revealed that in OLR case number this, applied by the transferee for conversion of Kissam land was allowed by Ajit Kumar Pradhan, additional Tahsildar. I am the petitioner. On 20th of March 2010, and ROR was corrected by the additional Tahsildar Ajit Kumar Pradhan, record keeper Amruta Kumar Jena and Amin fraudulently. RI Padmacharan Muduri misrepresented the fact without disclosing the status of the land, facilitating conversion and mutation of the land unethically. The status of the lease case was not verified prior to allowing the case, the land has been converted to homestead purpose, even though the lease was sanctioned for agricultural purpose.
Yes.
Therefore, I have exercised
Surprisingly, read it. Surprisingly, the order
1998 of additional Tahsildar in mutation case was ignored.
The order to redeem to was suppressed as a result of the suit land was not resumed to the government khata.
That was in 1998. I come into the picture only in 2006.
What is the manipulation you have done? I am
Well, I have
Page
passed,
92, Milord.
there is no,
92.
I have passed an order under section 8A of the
Passing
OLR.
of order is one thing.
Yes.
See, if he's 468, 467, 471 and all, once invoked, then there must be some manipulation.
Yes,
Might have
yes.
taken. I am searching that whether if you have manipulated the official record, then it is not coming under the color of duty.
Your
So
Lordship is
therefore,
absolutely
the
right.
sanction is not required.
Your
As
Lordship is
simple as that.
absolutely right.
Page 92.
If
Milord.
any evidence has come that you have manipulated the official record, then sanction is not required. You can be solicitor, prosecutor
Your Lordship is
for
right.
manipulation.
Yes.
That's right. Because it's not a PC Act or anything of
Yes.
that sort. That part he has to show me.
Page 92, Milord.
92. Yes. Which para?
Second para. The
16.21.
That
Read it. Additional. ADM.
That ADM Bhubaneswar by revision case number such and such has set aside the order of Tahsildar in Westland, lease case number such and such, couple of for irregularity committed in the matter of grant of lease, and they remanded the case to the Tahsildar Bhubaneswar, take up the case and complete the inquiry by his memo number such and such. Additional Tahsildar Bhubaneswar in remand case number such and such, arising out of revision case number such and such, passed in final order dated 12/8/1998 by cancelling the sanction of the lease and directed the record keeper to correct the ROR and RI Mendasal to take over possession of the suit land. But neither the order dated such and such ADM Bhubaneswar nor the order dated such and such additional Tahsildar Bhubaneswar was given effect. Taking advantage of this situation, lessee Prafullo Deuri transferred the plot to provide private person, and a transfer applied for mutation by mutation case number 2011. The said mutation case was fraudulently confirmed by the then additional Tahsildar Ajit Kumar, the present petitioner, on 30/4/11, and additional Tahsildar Devashish Mahanti being in the charge of the record room, along with the other, corrected the ROR by opening a new khata bearing such and such khata number such and by carrying out the illegal order of Sri Pradhan, knowingly fully well that the case land is originally government land leased out the agriculture purpose.
There is no
They are creating the new
forgery
khata.
from here.
No, you have created a new khata altogether. See, there was earlier two orders. That order is passed in 1986 and 1998 by resuming the land
Yes,
back.
The government.
In 19
And that was never carried out.
that was never carried out.
Rather, the people, those who were in the possession, they sold it to third parties.
Yes.
Those third party approached
Yes, ma'am.
you for the purpose of conversion. You have ignored this earlier order of 96 and 98, by which the land would have been reverted back to the government. Ignoring that order, what you did is you converted it to Goravadi and created a new khata and made the entries.
Therefore, your lordship may see how the state government deals with it. How the state government deals with the issue in the disciplinary proceeding.
Why have you not taken into consideration? There are two orders of 1986, 16/1/1986 and 12/8/1998, cancelling the entire sanction, and the lands were resumed back to the government.
My specific submission is that when in 1998, the then record keeper was directed to correct the ROR, he did not. Disciplinary proceedings were initiated against him and he has been found culpable. I was not aware.
Was it your case that it was not known to you? It must be their record. You created a new
It was not
khata.
known to me. It was not known to me. In fact, what the state government says in the dispute proceeding is that this was prevailing practice.
Prevailing practice to ignore the earlier orders.
This was normal practice, man.
And moreover,
Earlier order, resumption orders.
The earlier orders were not.
That was not challenged. That attained finality.
But the earlier orders, 1998, when it was done, since that record was not changed in 2010, we were not aware that what correction was made.
See, all the record must be there before you, not that it is not.
Your Lordship, kindly see the
Fact even
kindly
during
see this way proceed.
during the settlement operation, there is no power.
But I
to-
said disciplinary exoneration in disciplinary proceeding will not help you. That my judgment is there already.
Well, it's because disciplinary proceeding is on the question of preponderance of probabilities.
That's
And
right. That I have
preponderance of
said that will not help you unless you make out a case from the charge sheet that the act complaint against you is coming under the color of duty. Then you are protected.
Well, it's the allegation that is specifically against me is that I have passed an order under the OL.
Your allegation is twofold.
Yes, ma'am.
First allegation is you have ignored two specific orders of your seniors and you created a new khata and converted the lease land to Garwad.
And moreover,
agriculture lease land to Garwad.
during the
This is
settlement operation.
Twofold allegation. Ignoring one thing and second creation of a fresh document, ROR.
But it's when the ROR was never corrected. What I have that an ROR is corrected under the Odisha Survey Settlement Act. I was exercising powers under Section 8A of the Odisha Land Reforms Act.
Those
which is a
things
separate
may
statutory provision.
See, Mr. Behra, those things may be your defense. It's a good defense, no problem. I am examining whether the cognizance taken by the court in the absence of sanction is correct or not. Then the only thing what I have to see today is whether the act complained of is coming under the color of duty or
The act complained of is that I passed an order under the OLR Act, which was without jurisdiction.
and executing it by creating a new khata.
Well,
That
a-
is 468.
That is a consequent action of the order.
That is 468.
That is, well, that is not 468 because it is an act in discharge of my official duty. Once an order is passed under the OLR Act, whether it be correct or wrong, automatically a khata entry has to be made.
Show me that these orders are quasi-judicial orders.
Yes, ma'am. Your Lordship, your Lordship may kindly first see the disciplinary proceeding because that will shed a lot of light, madam.
Yes. Which annexure?
Yes. Your Lordship may kindly have Annexure 6 series, page 118 onwards.
Okay. Yes. Yes.
This is report on the inquiry in the disciplinary proceeding case number this dated.
We are reading 114?
118, madam.
18.
It's
Yes.
Your Lordship is right. It starts at 114.
14
we're reading
and-
at 118.
yes, yes.
Final report.
Yes.
Report on inquiry in the disciplinary proceeding case number this dated 15/9/14 initiated against Shri Ajit Kumar Pradhan, OS ex additional Tahsildar, Bhubaneswar. And your Lordships may come to page 119.
Yes. The statement and imputation shows that during his incumbency as the additional Tahsildar, he allowed mutation and conversion of land of OLR number so and so, so and so, so and so, relating to Muja so and so. His authority vitiated statutory provisions under section so and so. Muja was under the operation of the settlement during the period with an intention to provide favor to private individuals, embarking upon the procedural stipulations, and he was charged with the gross dereliction of the government duty, violation and prescribed procedure of law, and misuse and abuse of statutory powers, and lack of integrity and gross misconduct.
Your Lordships may see the inquiry and findings.
Inquiry and findings.
The charges were taken up for inquiry from the official record as per the delinquent officer appeared and heard in due consultation of the records. The revenue records available in Bhubaneswar Tahsil were verified. It is a fact that the officers of Bhubaneswar Tahsil were clandestinely allowing mutation under the camouflage of conversion of agricultural land into non-agricultural use under Section 8A of the OLR Amendment Act during the period when settlement operation was taken up in respect of certain villages of the Tahsil. The delinquent officer submitted his statement of defense and additional documents, which are made. Your Lordship may see the last paragraph. The government guideline was specific that when any village is taken up under settlement operation, conversion of land recorded with the private person can be taken up, and such orders of conversion would be communicated to the settlement authority for correction of ROR. Well, this is slightly important. Nowhere there was any instruction or order to carry out mutation of the land under the garb of conversion. This certainly is an infringement of the law, violating two statutory provisions simultaneously. It was latent and quite within the knowledge of the government authorities and was continuing for a long time till 2013, as has been indicated by the Tahsildar. The irregularity in the case as assessed under the statement of imputations is that Mauja Ghongapatna was under settlement operation while the above noted cases were allowed by the delinquent officer. It is a fact under statutory provision of Survey and Settlement Act that during the currency of settlement operation, the updation of revenue records by way of mutation are not entertained. However, the cases of conversion of land from agricultural to non-agricultural purpose are carried out under intimation to the settlement authorities under the provision of the OLR Act. Taking advantage of the position that conversion under OLR Act could be taken up during currency of settlement operation, the lands were taken up for mutation, which was a colored disposal. This is certainly dereliction in duty in allowing the prohibited action through other provision in order to provide benefit to the private persons defeating the provision of law. The marshalling officer indicated that as per the government instruction dated 8th February 2002, the Tahsildars are empowered to carry out conversion of land in a situation when settlement operation has been notified but not in progress. The conversion of land of transferees was being allowed without being mutated in Bhubaneswar Tahsil as a prevailing practice and no one had objected to it. The procedure was followed by the delinquent officer, which was in continuation till 2013. Besides, the disciplinary officer has issued intimation slip in form, the delinquent officer has issued intimation slip in Form K after disposal of case under Section 8A of the OLR Act. Delinquent officer is me, my lord.
Yes.
I'll read that sentence again. Besides, the delinquent officer has issued intimation slip in Form K after disposal of cases under Section 8A of the OLR Act to the concerned revenue inspector under intimation to the assistant settlement officer for taking necessary action at their end. The deviation of legal procedure was not only in these reported cases done by the delinquent officer, but has been committed in thousands by many officers. It has been clarified by the marshalling officer that in the pendency of settlement operations, no ROR was corrected by the delinquent officer in favor of any transferee till denotification. The argument that the OLR Act has got overriding effect over other laws under Section 3 is debatable. The law in amended provision of the OLR Act in Section 8 is very specific.
That's right, I understand. He says that this has been going on since 2013. So just it may be
it has
to be a dereliction of duty.
But they say which was practice and precedence in Bhubaneswar.
Wrong practice and illegal practice may be taken into account.
It is an exercise of it is an
Exercise of what power? It is finding it.
Under Section 8A of the Act.
The finding is it is illegal. But since the practice is going on since 2013, so it can be said to be a dereliction of duty. That's what the finding of the
that is not just the finding. There is a government
and he has intimated this aspect to the settlement authority.
Yes, there is an instruction called 8th February 2002. There they say that where settlement has begun, but settlement is not in effect, mutation or conversion can take place with intimation to settlement authorities. That is exactly what I have done.
That fact is the 10 and 11.
That is exactly what I have done. Besides, the delinquent officer has issued intimation slip in Form K after disposal of cases under Section 8A of the OLR Act to the concerned revenue inspector under intimation to the assistant settlement officer for taking necessary action at their end. Therefore, this is absolutely in discharge of my official duties under Section 8A of the Act.
Yes, what do you say?
Once settlement operation is going on, then no court has power to correct the. Apart from that, he has changed his nature of the character of the land. Settlement operation la matlab sabu seize.
No, you just tell me whether this order passed under which provision?
Section 8A of the OLR Act.
You just tell me whether a order passed under 8A of OLR Act is a quasi-judicial order or it is an administrative order. Answer.
My submission will be it is a.
No, you show me that quasi-judicial order.
Your lordships may have this matter tomorrow. I'll pull out some judgments.
Come tomorrow. You simply say if it is a quasi-judicial order, then the scenario is different altogether. You get those judgments also.
Yes.
If quasi-judicial order, then no mancheria. If the appeal and every provision is there, you go and challenge it and get it satisfied. That's a different story.
And if it is not a quasi judicial order, then the manipulation is there, then sanction is not required.
Your lordship,
And police has not gone for sanction because of this kind of the inquiry. The inquiry, according to me, is completely, he says that the practice is going on, so therefore let it go. He says, having said that it's the illegal act, since 2013 this practice is going on, so let it go.
Well,
What is this?
let me show your lordship something very
So
interesting.
therefore your department and senior officer are also helping you out.
Your lordship,
That's the reason the police has not gone for sanction.
your lordship may see something very interesting. Page 121.
120.
Inquiring officer.
Yes.
Name of the inquiring officer, your lordship may see.
ADM.
Abanikanta Patnaik. Same officer who had lodged, who was the informant in the FIR.
So that's the more of a reason why these people have not gone for sanction. They know that they will not get sanctioned. Because this is the ADM passes an order, and another ADM is the inquiry officer. He see the finding. He says that since this is going on from years together, having found that this is an illegal act, since it's going on, thousands of cases has been done, so therefore it is dereliction of duty. What is this?
At best, it's not an illegality, but it is an irregularity because there is a line
He
here.
doesn't say irregularity. He says that it is illegality, but after having done it, it has been intimated to the settlement authority. Therefore, it can be a dereliction of duty.
But it is as per the guideline, as per 8th February 2002 guideline of the government.
See, intimation is subsequent to the order passed.
Yes.
So use order 8A order was passed, thereafter the intimation was done. Because settlement, see, after the order is passed, it has to be intimated to the settlement authority, to the settlement inspector. What he did is, he created everything, thereafter he passed on to the settlement inspector.
Your lordship may see the 8th February 2002 notification.
The offense has already been done by that time.
Your lordship may see the 8th February 2002 notification which is described here.
Where is that?
The third paragraph, your lordship may see again.
Yes.
The marshalling officer indicated that as per the government instruction dated 8th February 2002, the Tahsildars are empowered to carry out conversion of land in a situation.
Who says you have power to do it? But in the fact scenario of the present case, once it is vested to the government, can you do it? It's a government land.
The main allegation against me is that I have done it.
The inquiry officer goes with what premises? Your power. Who doubts your power? You have a power under 8A. You can pass. But see the fact scenario of this case. These are the lands, government land. It was given on lease basis to XYZ. And a proceeding was drawn up in 86 and 88. And it was reverted back. It has to come to the government. That orders were not carried out. Rather, the same XYZ sold it to many people. And those people have come and asked for the conversion. And you allowed
settlement operations.
You allowed it.
Well, it's when admittedly, when settlement operations are ongoing, no conversion, no mutation can happen. Admittedly, that is the case. 1995.
All these things are your defense. You can tell us.
Well, just 1995 it started the settlement operations. 1998 record keeper is directed to make changes in the ROR that he could not have done. Because 1995 settlement operations.
Oh, no, I just wanted to know whether it is coming under the color of duty or not. That's all.
But it is a power exercisable under section 8A of the
8A is a quasi-judicial power, then...
It is quasi-judicial. I'll show you lordship judgment.
Show me any judgment or anything of that sort.
Tomorrow, your lordship.
Then tomorrow. Then you have a case.
Yes.
Then you have a case. Otherwise, you have a very different...
Next week, my lord, so that's
Why? I have heard so much. We can dispose it up. What is this? Is pending stay order is operating ceased to... Why you are supposed to get ready? Rather, you should be anxious to get it disposed of. If the interim order is going on, I'll adjourn it on your request, my lord. Let him come. If he can show me that, then straight away he's covered.
It is possible.
Yes. Why should the matter will be pending? We'll dispose it up. Yes. Yes.
I thought 39 has been passed over. The other
Yes,
side
that-
is not there. It is for pausing. And it is a trivial matter for which your lordship was pleased to grant this stay and also was.
The stay is operating, let it be.
My lord, 2 students are there. And one of the.
See, out of 9, 2 students are there. I have seen it. The stay is operating. Let us see.
Tomorrow, my lord,
Tomorrow may not be possible.
Let me take my chance. If
Tomorrow for taking chance. I'll write it down. Tomorrow.
obliged.
Item number 45. That your lordship has fixed it at 2:30. Click on the line.
Acha, acha. Oh, yes, yes. 45, that settlement matter. Okay.
44 also, ma'am. Your lordship there.
Oh, okay. The settlement. I'm coming there because it's passover matters. How could I passover?
T 1, 42, 44, 45, 46.
It's just I'm coming. Huh? Like this, serial. 41. All passover matters. Within 10 minutes, I'll. Yes, yes.
Lord, hear me, Lord. The impugn order is the order of cognizance taken by the learned magistrate, my Lord. Now the order is challenged on 2 grounds, my Lord. That at one stage the learned court below has taken cognizance of section 420, and the other stage, my Lord, they have also taken cognizance under orders, my Lord, under section 409, my Lord. My humble submission is, my Lord, the section 420, 406, and 409 they cannot coexist, my Lord. Lordship must have.
There is a recent judgment
Yes,
for Justice R.K.
That's
Patnaik.
right.
Where is that?
Lord,
Where is that judgment?
Lord, this judgment is with me, my Lord.
You have?
Yes. Yes. I have the Supreme Court on Supreme Court
But
judgment.
Justice R.K. Patnaik passed a
Yes, my Lord.
detailed judgment. 406 and 420 doesn't coexist.
Yes, your Lordship.
That's what it is.
Yes.
Come tomorrow. Come.
Lots tomorrow.
Come with all judgments.
Yes, Lord.
Yes. Next.
52.
I am from my Lord. Mr. Raut was conducting this case, my Lord. He has expired on last month. Kindly 1 week time may be allowed.
On requested. Yes.
44.
Entry order continue.
Yes. 44.
And 44, my lord, lordship, my lord, to file the dispensing petition, and I have already filed. And they have also asked the question to the, my lord.
What is the settlement term?
They are staying together.
They are
Staying together. Okay.
498.
At the instance of the petitioner is an accused, Olga Pratham only husband. Pratham only husband. Second Olga. Even Pratham petitioner is an accused. At the instance of the opposite party number 2. FIR number the petitioner had approached this court for seeking passing up the entire passing up the FIR. The investigation is going on. Investigation is going on. At this stage, the parties have entered into a settlement. Opposite party number 2, so petitioner and opposite party number 2 are personally in the court. On specific query from the court, they have conjointly submitted that they have settled the dispute and they revived their veterinary relations. On that premises, they are jointly paying for passing up the present FIR. They have also filed both the petitioner and the opposite party number 2. Those who are present in the court are being identified by their respective counsel, and they filed the self-assured photocopy of Aadhaar card to establish their identity, which is taken on record. They have also filed a separate affidavit, or
That is separate affidavit.
they have filed joint affidavit. They have also
Joint affidavit, flag A, flag P, my lord.
they
Already
have filed a joint affidavit.
in the flag, my lord, P, flag A.
Dated 5/1/2026, inter India, stating as under para 3, 4, 3, 4, 5, and 6. 3, 4, 5, and 6. On specific query from made by the court, the opposite party number 2 submits that due to misunderstanding, she had filed the FIR. She has no grievance left against the petitioner or the family member of the petitioner, and she submits that the prosecution initiated by her legal was regarding her two statements also concurred. In the other matter, petitioners photo, the petitioners are not present in the court. Petitioners are not present. The petitioners are the in-laws of opposite party number 2. They are not present in the court. Therefore, an application has been moved by the counsel for the petitioner seeking the exemption of their personal appearance from the court today. For the reasons stated in the application, the same is allowed. Same is allowed. Baki so same. So submitted appearance for opposite party number 2 and files were covered. You give your photocopy of file, right? Yes. Yes, yes, madam, 45.
45.
Yes. 45.
The petitioner is on receipt.
Tell him, where is he?
Ajit Kumar Tripathi.
Ajit Kumar Tripathi.
Yes, Lordship.
Tell him, he's not there. Call him.
Sir, he's on.
Who has sent to mediation? This court has sent to mediation? Huh? Huh? By which order?
In ABLAPL 14370 of 2022.
ABAPL, huh? Filed by the petitioner.
Yes.
The petitioner, you call him, huh?
Sir, he's gone.
The petitioner had filed ABPL number
ABLAPL number 14370.
14370 of 2025. 22. The coordinator of this court by the order dated ABPL number. Co-order report high class.
Only 2023.
21.
3 of that affidavit, annex 2.
21.
2023.
2023 has referred the matter to the High Court Mediation Center for exploring the possibility of mediation between the petitioner and opposite party number 2. The mediation is successful. A report has been placed. Where is the report? Flag?
And that affidavit before the mediation is annex 2.
Annex 2. Annex 2. Mediation report. 3. The mediation has become successful, and where is that? Annex 3. No, that is joint affidavit.
Affidavit.
Annex 2 is for mediation report.
Annex
2 is mediation report.
mediation.
Deed of compromise.
By way the High Court Mediation Center, by the mediation report dated take it over here, Annex 2, mediation report dated so dated 29/3/2023 has reported to this court that the mediation is successful and the parties have settled their dispute. Subsequent to the mediation report, the parties have also filed a joint affidavit in the enclosed on 7/7/22, 23 before the in ABPL number 14737 of 2022, 2020. And thereafter you got the bail. Where is the date of bail? Taking into consideration the mediation report and the joint affidavit filed by the parties, the coordinate bench had allowed the ABPL number so and so and protected the petitioner. Protected the petitioner from no coercive action. Since the mediation is successful and the parties have settled their dispute, the petitioner has approached this court seeking passing of the entire criminal prosecution initiated against him by opposite party number 2. The FIR was initially registered against the petitioner by opposite party number 2. Inter alia since the dispute is essentially arising out of a monetary transaction and the parties have settled their dispute through mediation process at the intervention of this court, the prayer made by the petitioner deserves merit to be allowed, the petitioner, where is that petitioner? Petitioner and opposite party. Petitioner is appearing before this court through the visual mode. He has been identified by the counsel appearing for him. And opposite party number 2, or the informant, is he is present in the court through the both of them have filed their self-attested copies of Aadhaar card to establish their identity, which are taken on record. You identified him? He's Mr. Ajit Kumar Tripathi. Is your client, Ajit Kumar Tripathi? Okay. Regarding has been information cost. Okay. You give your Aadhaar card and all. Yes. Next. Appearance. Don't find appearance, files vocal account, is taken on record. Yes.
46. Next.
So if I may please your option, Manoj.
Yes.
Manoj, for pausing of the entire proceedings, wanted the judgments, Manoj. No, this is your lordship's recent judgment. And also the Honorable Apex Court judgment for Romeo and Juliet law, Manoj.
Which paragraph of this judgment, Supreme Court judgment?
Your lordship's judgment, my lord, relevant part starts from page number 5.
5.
Yes. Your lordship will see the below part. My lord has categorically distinguished Ramji Lal, wherein, my lord, it was a teacher who had exploited a minor girl. And then your lordship may please see page number 6.
Yes.
Sexual exploitation and adolescent love.
52. Will you show anything?
My lord, that is the 4 exhibit. That is
Huh?
there is a 4 exhibit, exhibit 11, 12, and 4 and 5. And one eyewitness is there, that is the PW4. That much.
Everything is hodgepodge.
And the evidence of the DW1 with the star witness, they are saying something, and they are in the cross examination, they are saying that on the behest of the accused person, we are disposing of all these things.
He was the only eyewitness basically, was present outside.
The PW4 is the another eyewitness.
I'll see. Okay. Okay. We will see. The judgment. Just see. PW4 is another eyewitness. And the DW1 who was the real eyewitness. All the witnesses have said all the two injury. PW1 is the informant. PW2 is injured son.
3 is
And
injured.
PW3 is injured mother.
Yes.
And all of them said Basia, what is his name? Basia Sahu. Basia Sahu. He was there. And he was not examined by you.
Yeah,
And they have encased the situation and
Bhagasa is not.
and they examine him as a DW1, isn't it? That's the case. We'll see. And one PW4 is one of the eyewitness. according to you. PW4 is.
And the other my submission by my senior my lord, the FIR was lodged before the police station, and the IO has stated an informant statement of the informant in corroborated the IO also. IO says that the judge present in the police station and lodged a FIR.
The medical evidence is created.
That medical evidence, but in fact, my lord, that the doctor who has examined, he has, on that day, he has on duty the another village for the epidemic.
What fact remains means, have you spoken to him?
No.
From record you tell.
On the record,
fact remains what?
On the record, my lord, PW9, that doctor.
I read it PW9 in
PW9.
Essential.
এবং
See, the requisition and evidence of PW9 are not matching.
That part
it's not matching. And the PW9 says that I have referred these people to Titlagarh police, what do you call Titlagarh hospital. And they were taken to Khariar Road. And insofar as Khariar Road is concerned, no doctor is examined, nobody is examined, no document is placed. Then what happened to this thing, the treatment part? But it's all hodgepodge. We'll see. Yes. Next. 53.
That judgment is reserved.
Yes, but appeal, no, sir. So, where the appellant has been convicted.
Last time, so let me use short time. Ready this time?
Oh, I'll do it. I'll do it.
It's nothing, but that's 337, 448, section 3. Section 3 is not made out. And 337, 448, only 3 months conviction.
3 months.
15 days custody.
Already undergone.
No, 1 year conviction.
1 year, 1 year for what? 3. Well, let me see the evidence of PW1. In view of violence husband
1
and
year conviction.
well, let me see section 3. With regards to
Page
section 3.
15. Page 15 is the relevant portion.
Well, initially the case was
Then see, for section 3 of SC Act 1 year.
1 year, but that is not made out in view of violence judgment.
And the remaining for the remaining offences
3 months.
3 months. So
3
it's
months.
technically 1 year old.
1 year.
Who is the victim?
Victim PW1.
PW1. Yes. PW1, yes, really.
Instead of giving Milo's valuable time, I was saying so. Well, let me see. I know the accused in the dock. I am the informant. I am a scheduled tribe belonging to Kandha subcaste, so subtribe. The accused is a non-scheduled tribe and non-scheduled caste person. He is Sundhi by caste. This is the entire evidence with regards to scheduled caste. And whether this case will come under scheduled caste or scheduled tribe.
I was sleeping in my house and the accused entered into my house and forcibly.
That she has
No.
not stated in the affair.
Hey, what is that? Forcibly bounced upon. Bounced upon me.
And slept over my body. When I raised Allah and called my mother, the accused caught my neck. When my mother came, the accused left and went away. My husband or my father was not there. When I proceeded with my mother to report the fact to Panchayat secretary, the accused threw
Big bag.
bats at me.
What is the period undergone is 15 days.
My lord.
Just write down. Okay. 15 days.
That can be done. Period undergone can be done. 1 year of sentence. Circle काय.
But period undergone can only be done if 3-1 goes.
3-1 goes. Yes, sir. Lordship, you can mail that.
Yes,
CO
3-1 goes and 3-1 goes and remaining.
Yes.
In the similar line also, another judgment has gone through by Justice Sibo Sankar, sorry, by my lord. Another judgment is there, my lord, Chaitanya Prasad Sahu and others. And also,
what does it say?
Same, my lord.
Okay, same thing.
Right. All three judgments are of my lord.
That's all.
Order Karni.
Okay, all the three judgments. All give all the three judgments. Keep all the judgments. This line that's 3-1 equity and remaining non for all. Yes. Okay. Next.
Item 60.
No, dakho, pura dakho.
At 54.
Password.
55.
99 from 55. 55, just see. Is there any report to be submitted? TCR has come?
This is trial court is available.
Yes. Next. 56. These things will remain. TC. Yes. Yes.
56 का 54 का option है ना 55 का
Yes. TCR is not there.
Is there?
Current counsel for the appellant. Your amicus curiae?
Yes.
The amicus curiae submits that. Okay. He doesn't have the copy of the TCR. Let him obtain the soft copy of the same. Release the matter.
57.
Challenging the conviction under section 20B of the NDPS Act, Your Lordship. There were two appellants in this present appeal, but one appellant has passed away. And I'm only challenging the conviction with respect to appellant number 1. Rukmini Pratap.
Appellant number 2 has gone.
Yes, Your Lordship.
Yes.
So, Your Lordship, on 10th February 2001, the informant, that is the SI of police, received reliable information that appellant number 1 is clandestinely possessing certain amounts of ganja, and she has taken shelter in one of her friend's house, that is Kirtan Das, who was the husband, also the husband of accused number 2.
10 witnesses were examined. Huh?
Yes, 10 witnesses were examined, and
there are how many exhibits? 10 exhibits.
10 exhibits, Your Lordship,
Okay.
and 10 witnesses, and they were charged under section 20B of the NDPS Act, and the order was passed on 19/11/2001, and whereby they were sentenced to rigorous imprisonment of 2 years with fine of 2,000 rupees.
What is the period undergone?
Yes, it has, but I am only arguing because there is a blot on this particular appellant, and I just want the appellant to live a life of pride after whatever life she's left with, because this conviction has been made. This conviction is completely vitiated because it is made under non-compliance of section 42 and section 50, primarily of the NDPS.
Show me 50 non-compliance.
50. Your Lordship, for section 50, I request Your Lordship to come to the statements of first PW 8, Your Lordship.
8. Yes. Who is he?
PW 8 is the ASI of police, who was one of the accompanying Havildars.
What's your
in the reading party, Your Lordship.
Hmm.
In the first paragraph, he says, first paragraph, second last line, Your Lordship.
Yes.
He also disclosed before me that requisition had been sent to the executive magistrate to remain present at the time of the house raid. My point is that, Your Lordship, executive magistrate the accused persons should have been brought to the executive magistrate as per the mandate of section 50 of the NDPSL. And the concerned magistrate should not have been a part of the reading party. If he is, then as per the judgment of Honorable Supreme Court in state of Rajasthan versus Parwana, then that particular conviction is vitiated and it cannot be because presence of that particular executive magistrate as a reading as part of the reading party will not be considered to be independent enough.
He's also disclosed before me that requisition
Has been
has been
sent
sent to the executive magistrate to remain present at the time of house raid. Okay. The magistrate, if the magistrate is a party to the raid,
Yes.
then the entire thing goes.
Yes, Your Lordship.
That is it.
I have a judgment, Your
Has
Lordship.
the requisition was sent? Was he there?
Yes.
Where is that?
For that, I request Your Lordship to come to page 65 of the paperwork, PW9, who is the executive magistrate.
Which paragraph? It's the executive magistrate. Executive magistrate himself.
Yes.
Have the police to contact me.
Last week.
Hmm.
Accordingly, the OIC with the staff came to my office and I accompanied the police party to village Dhatia Sai within Jajpur Road. In the third paragraph, next page, Your Lordship, page 66, para 3, after two females were caught, Your Lordship.
After two females are called.
They disclosed before those females their purpose of rounding up the house and expressed their intention to search them personally and also their house. I also gave them my identity to those females. That I was an executive magistrate. I myself, as well as all the members of the police party, gave personal search before the witnesses and
Show me the judgment. Show me the
judgment. Your Lordship, paragraph 14, Your Lordship, of this judgment.
Yes.
14 and 15 to be precise.
15.
15.
Reading. You also notice PW10, as I informed the respondent that there could be searched before the nearest magistrate and before the nearest gated officer. Before PW5, GST, the superintendent and who part of the reading party. It is the prosecution case that the respondent informed the officer that they would like to be searched before PW5 by PW10 assigned. And this, in our opinion, is again the breach of section 50 NDPS Act.
Yes, Your Lordship.
The idea behind taking an accused to the nearest magistrate and a nearest gated officer, if he so required, is to give him a chance of being searched in presence of the independent officer. Therefore, it was improper for PWC to tell the respondent that the third alternative was available and that they could be searched was national. He was a part of raiding party. He also cannot be called an independent officer, and he is expressing in the opinion whether so. Yes.
Yes, Your Lordship. And Your Lordship, if Your Lordship comes to section, paragraph 14 in the same judgment.
Yes.
The presiding paragraph. Over there, it specifically stated that a joint communication, that the mandate of section 50 will only be said to be complied with if there is a separate communication made to all the accused persons who are about to be searched. In the specific case, Your Lordship, there was a joint communication made.
Joint communication forbidden.
Yes, Your Lordship.
Joint
paragraph
joint
14.
communication forbidden. Joint
Paragraph 14 of this particular judgment.
communication forbidden.
Yes, Your Lordship. And that is
Forbidden.
In fact admitted by PW7, who is the SI.
Magistrate, part of raiding party.
Yes, Your
Part of raiding party. Raiding party. Yes. Joint communication. Show me joint communication.
Yes, PW7, if Your Lordship comes to 56 of the paper book, page 56.
Yes.
56, I'm sorry, Your Lordship, page 57, the next page. Your
Yes.
It is 8th line, your lordship, 8th sentence.
I disclosed before.
I
We
disclosed
detained
before
them at the backside
they
of the
decide-
house. I disclosed before them
Yes,
that if they discard, desire, they might be searched before the executive magistrate, to which they consented. Accordingly, I and the executive magistrate, so and so, so on. Yes. Now, what do you say? On both the ground, you are out.
Lordship, paragraph 15 of the judgment, page 25.
Your judgment. Trial court judgment.
Impugned.
Yes, we directly hit by this Supreme Court judgment. See, she has pointed out two things.
Yes.
One is for compliance of 50, if there is more than one accused, separately you have to communicate that you will be searched by a magistrate. Are you willing or not? I will do it, or through magistrate we will do it. This requirement of section 50. Separately you have to communicate. And the IO says that I told them, jointly they told them. Para 14 of this judgment says jointly communication is forbidden under law. This is first point. Second point is section 50 compliance. The magistrate you have to take to the nearest magistrate. You can't carry the magistrate with you in the raiding party. If he is a part of the raiding party, then he is not an independent person. So section 50 is not compliant. These are the requirement under this. And she has pointed out what remains.
That is, they have distinguished that raid and search. It's a raid.
Your lordship will.
It's a raid, not search, personal search. Your lordship, 15, para 15 of the impugned judgment. In the instant case, the prosecution case as well as evidence clearly manifests.
Para 15?
15 of the impugned page 25.
Yes. In this case, it has been decided by the Honorable Apex Court in section 50 or mandatory.
The para is double,
Yes.
25.
In the instant case, the prosecution
In the
case
instant
as well
case,
as
the
evidence
prosecution
clearly in manifest that the spot of house was simply raided and not searched. And therefore, section 42 of the Act has no application at all.
Section 50
Section
Act is
50 of
the
the
personal
Act
search.
deals with the
Personal
personal
search.
of
With respect to that, Your
but
Lordship.
she says that two women were found and they were asked for searching and all.
No.
That was done there only.
Made for the raiding, not search, personal search.
No.
After raid.
1 minute. He read out where that.
Yes. The Lordship see that.
Where is that portion you read? Where magistrate? Where is the magistrate?
Magistrate.
Executive PW 9, my lord.
9.
PW 9. That from 5/12/2000, I have been working as the Tahsildar Sukindar, come executive magistrate at Jashpur Road on 10/2/2001. I was also working in that capacity. On that day at 1:30 p.m., while I was in office, the YC Jashpur Road PS informed me to accompany the police party Jati Sai for raiding. For raiding, that is important.
Para
For
3.
raiding a house.
Para
there
3. Para 3. Read para 3.
Para 3. After two females were caught red-handed by police, they disclosed before them these females their purpose of rounding up the house
and express their intention to search
the personnel.
them personally and also their house.
But it's a preliminary that is raid.
Your lordship.
Subsequently,
Search was conducted. Once the moment you conduct the search, 50 steps in.
Because for the purpose of raid, magistrate accompanying by the police raiding party.
That's not the magistrate doesn't say that. He carried out search also. He carried out search also, para 3.
Even the SI PW7 is also said.
You can't read one paragraph, you have to read. I also gave my identity to those female.
Yes.
And I was an executive magistrate. I myself, as well as the member of the police party, gave personal search before the witness, before the accused persons. Everything, the search is done.
The search was done.
Then
after raid,
they went for raid, took the magistrate, conducted search in the garb of complying 50. Therefore, she says
Since,
directly quoted.
since magistrate was part of the raiding party. or
That is
raiding
what
the
the
house,
that is
and it
what.
was been the-
No, that is what the
intention
judgment says. If he is a part of raiding party for the purpose of section 50, he should not be used. That is the judgment. You should have brought another magistrate or someone else. You took you requisition and took him along with you. What is this?
And they should have been taken to a
Human
magistrate.
give me information as
So-
get to the Tahsildar as stated by the prosecution.
Your
And also, say of police also stated that.
No, the para 14 and 15 of this judgment, she directly covered.
And your lordship, there is also another Supreme Court judgment that I'm unable to find right now, where the word raid and search has been used synonymously.
Many judgments.
Apart from
Raid
section,
is different from the search.
lordship, there has also been misinterpretation of the law with respect while applying or while deciding the sentence of the accused.
What is that?
Because the accused has been punished under section 20B, which says, which before the amendment of 1/5/2014, if the person was carrying a small quantity of ganja, that is, which is till 1,000 grams, and only 300 grams was procured from this lady Rukmini Pradhan, then the person would be imprisonment to the extent of 6 months. Whereas even after knowing that, or even after it is being shown by the prosecution that she only had 300 grams of ganja in her possession, she was sentenced to 2 years of imprisonment.
Which you have already undergone. 2 years you have already undergone.
Yes, she has already undergone. And that has been
1
wrongly
kg,
undergone.
300 total salt seized. Say 1 kg from the plan number 2. That.
Till a
Only 1 kg from PW 2. Sorry, appellant number 2 who died. 300 from him. Consequence. He says that
lived still.
No,
No.
In the-
One is an
in the case then. Which provision you are talking about?
Section 20 clause B, your lordship.
It prescribes 6 months.
6 months before there has been an amendment. Presently, it's extended.
Amendment when?
Amendment 1/5/2014. And she has been.
Before that it was 6 months.
Yes, before that it was 6 months.
The judgment was 2003.
2003. So as per 2000, as per the law prevalent in 2003, she should have been imprisonment up to 6 months. And not.
But how do the magistrate know that there will be amendment? Where is it? 20? 20?
20 amendment is 2001.
14 amendment.
2014.
20B.
Substitute that
20B.
20B.
20D.
Commercial and small quantity girls in
Manufacture, possess, sell, transport.
B as in Rome B, subclause 2, clause A, capital A, and involves where such contraventions.
Small quantity with rigorous imprisonment for a term which may extend to
1 year now.
1 year
after
or
the amendment.
with fine. Before that too,
Before-
substituted with 6 months, huh?
Yes, sir.
6 months. 1/5/2014,
Yes.
it was amended. That is 20,
1/5/2014.
section 20, 20 capital B, 2
Yes.
capital B,
Capital
Yes.
B.
capital B,
Commercial quantity.
6 months
That-
before amendment, on, that is 1/5/2014.
2014.
So 2 years is better than 14.
Yes, sir.
2% थोड़ा लिखते रहेंगे। council excellent. Relying upon the judgment of state of Rajasthan, Parmanand submits that the impugn judgment is liable to be quashed on two grounds. Firstly, there is a joint communication made by the IOs to both the accused persons regarding compliance of section 51 of NDPS Act, which is forbidden under law. For that, he relied upon para 14 of the law. Secondly, he has also submitted that the searching magistrate, in compliance of section 50, the searching magistrate should not have accompanying the raiding party. The evidence reveals that in the present case, the PW9, the magistrate was requisitioned by the police to accompany the raiding party. He has not only accompanied the raiding party but also carried out search. Therefore, on that count also, section 50 is not compliant. Not compliant. She also submitted that insofar as sentencing part is concerned, the same is also against the law, because section 22 capital B prescribed maximum sentence of 6 months before the amendment, before it suffers the amendment on 1/5/2014. After the amendment, the sentence is extended to 1 year. Extended to 1 year. However, in the instant case, the trial court having convicted this appellant for offence under section 22B of NDPS Act, convicted for 2 years. She also submits that although the sentence was not in conformity with the provisions of law, the appellant number 2, the surviving appellant number 2, has already undergone the entire period of sentence. This much you write down in a case of compliance of 50.
Appellant number died.
Number 1, appellant number 1, 2 has passed. Non-compliance of 50 straight away in 2 counts.
In fact, it's a very technical. So the magistrate was there.
See, the procedural safeguard given in the NDPS has to be very strictly complied, isn't it?
Non-compliant section 42.
42 was compliant.
You succeed in 50, then why should you?
42 is compliant. Technically,
Yes. Yes.
Regular 2 months conviction under T2.
Which one? 57?
1
1 year.
58.
1 year conviction. 2 months. 2 months is.
Yes.
50 1 year. 1 year. 1 year.
1 year.
1 year. Yes.
All matters necessary pending.
Period and the election.
Yes. Yes, madam.
May I please?
What is the offence?
Your Lordship, offence under section 457 and 354 of IPC. Total number of witnesses are 7. 7 witnesses have been examined. All of them are, Your Lordship, the interested witnesses, no independent witnesses, Your Lordship. Lordship, the prosecution story says that on 9/7/2005 at about 12:30, entered the petitioner entered into her house with the house, put up the lamp clamp and the mouth of the informant, showed the wearing appraisal and slept over her and attempted to rape her. While she raised Hulla, her children woke up. At that time, the husband of the informant, along with his friend Kalicharan Patra, who is
the victim?
PW1, Your Lordship. And PW2 is the husband of the victim, Your Lordship.
Is the informant? Who is the informant?
Informant is the victim himself.
Victim herself. Okay.
At the time of at that time, the husband of the informant, along with his friend Kalicharan Patra, who is PW3, Your Lordship.
Husband is PW2,
PW2,
Kalicharan is PW3.
PW3.
Yes.
Is the friend of the husband?
Okay.
Friend of the husband. Also reached and the parties.
Then husband and Kalicharan are post occurrence after the incident.
Post occurrence.
Yes.
Yes, seen that the person, but
I'll come
Let
to
us
that,
see.
Your Lordship. I'll come to that, Your Lordship.
Yes.
Flew away from the spot, pushing back to the husband of the informant and pushing him in the filthy languages, abusing him in the filthy languages, and also threatening them to kill. It was also alleged that hearing the hula, some of the villagers were gathered, including some persons neighboring village, Dulida, and the matter was also reported in the Gram Rakhi, sorry. And subsequently, the information was lodged in the police station, Your Lordship. Your Lordship, the deposition copy, page number 20, Your Lordship.
You read PW1 first. Let us
Yes, Your Lordship. PW1, the relevant para, Your Lordship. Paragraph 2, page 21.
No, the first, the incident, let us understand.
Okay.
The first para 1 in between you.
Your Lordship.
Order was passed on
Release on bail. 12/1/2017, 7 bail granted.
13/12/6 judgment.
13/12?
12/7 bail ହେଇଛି।
Just count like that. Count like that.
କେତେ ଦିନ conviction କରିଥିଲା?